Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near, and they will be heard. God save the United States and this honorable court.
Well, good morning, everyone. We have 5 arguments this morning. I'd like to just thank all of the lawyers for accommodating this Zoom argument day. We did this during the pandemic, so it's not a new thing, but I know you were not planning on this, and of course, neither were we. So we'll make the best of it, and I think we'll be fine getting through the morning. We will probably take a break after the 3rd case, which is the Alliance case, and then come back and pick up the Root case. That's our intent, but we'll see how things go. The first case this morning is Garrett versus Denver C.A.R.E.S, and it's number 24-1363. And I think with that, we can begin that argument. As I understand it, is it Ms. Clark who has the appellant, or do I have that wrong?
That's correct, Your Honor.
Okay. On screen, they don't have, I think they don't have your name quite right, unless...
This is always an issue professionally. I go by my maiden name, Robin Levine.
Oh, okay.
But by law, it's Robin Clark, and whenever I'm in federal court, I cause all kinds of problems with this. And if I could actually have just one moment, because the light in my office is flickering. And
Sure.
Acting. If you give me just one moment.
See, it's not just the lighting in my office. I was having similar issues earlier this morning.
Okay.
You guys know I'm not alone here.
So it's Robin Levin, and Robin B-Y-N, and the reason I noticed that is that's how my wife spells her name. So with that, let's go ahead and proceed.
Thank you, Your Honor. Again, my name is Robin Levine. I represent the appellant, Brian Garrett, in this matter. And if possible, I'd like to reserve 4 minutes of my time at the conclusion. May it please the court, this case deals with standards for warrantless seizures, which are not based on criminal wrongdoing. It was dismissed on a Rule 12 motion, despite a number of factual disputes. Specifically, appellant Brian Garrett was taken from his home to a facility where he didn't want to be. The facility made no specific findings that he was a threat and didn't actually provide treatment. Instead, Mr. Garrett was laughed at, lied to, and threatened with extended detention in retaliation for saying that he didn't think this was constitutional. And insofar as the facility disagrees with these characterizations, that is exemplary. It is illustrative of the factual disputes here and why this matter was inappropriate for dismissal at the Rule 12 stage. What is clear and undisputed is that unlike typical seizures, which would be based on somebody making a finding that the detainee broke the law, this kind of seizure is supposedly for the detainee's own good. But the facility never engaged in the process it's required to engage with to determine whether he needed to be there.
Let me stop you for just a second. So the purpose of the detention is not just for the detainee's own good, it's for the public's good as well, right? I mean, the determination is whether he's a danger to himself or others.
Yes, Your Honor. It could be it can be for either purpose, right. Okay. For his own good or for the good of others. But regardless, there were no specific findings on either point that he was a threat to himself or others, nor was the process which would determine that ever engaged in, which would be the emergency commitment process. So essentially, without any accusation of any criminal wrongdoing, Mr. Garrett gets caught up in this dragnet. He's brought to this facility where they seem to believe that just because he is brought there, That means that they can, without any formal process, any commitment process, keep him there. And that can't be so.
Could I just ask, Ms. Levin, so just breaking this down, we have the Denver police go to the home. They're not parties to the case, correct?
Correct.
And then the emergency service patrol comes to pick him up, takes him to the facility. And so I wanted to ask you just a question at that point, and that is the probable cause that the emergency service patrol needed to take Mr. Garrett and transport him different from the probable cause that the facility would need to detain him there? In other words, you've sued, I mean, one of the defendants was part of the emergency service patrol. I'm just wondering if we evaluate that person or the patrol's conduct differently from the way we evaluate the facility's decision-making.
Yes, Your Honor, you do evaluate them differently. Because it would, and I would say analogously to the way that you evaluate a officer's probable cause finding on a warrantless arrest versus the finding of probable cause by a magistrate. That at the facility, once this person is in the facility, and it is reasonably feasible to engage with the process that allows for a neutral decision maker to consider the probable cause, they're required to have that neutral decision maker get involved in order to approve or disapprove of the emergency commitment and to look at the specific observations and decide whether or not those do justify a continued holding. And I should add to this, it's once they're at the facility, it's been enough time that it's reasonably feasible to get that review, and they are aware that the person does not consent. And I think that the easiest place to look to see that that's the case is the regulations. So at page 27 of Denver C.A.R.E.S brief, they cite to a set of regulations that control Denver C.A.R.E.S and its conduct. And number 6 is for discharge planning. And what that says is that they need to have a policy in place such that if somebody's receiving services on a voluntary basis, which purportedly is what was happening with Mr. Garrett, despite his clear statements that he did not want to be there. If somebody is receiving services on a voluntary basis and they say that they want to go and medical personnel doesn't think they should, what the regs say is, okay, then the facility has 2 options. Option 1 is to let them go. Open the doors. This is a treatment facility, not a jail. Let them go. Option 2, if there is a reasonable basis to believe they're intoxicated and clearly dangerous, initiate the emergency commitment procedure. And I do think it's worth noting that the emergency commitment procedure, unlike, say, a Gerstein hearing, is a purposefully designed low barrier process. And what I mean by that is that I think the most instructive case is Carberry, which is a Colorado case, but it's a determination that's made soon after the statute was passed. And the question there was, with this emergency commitment statute, do we need a magistrate? If you want to hold somebody for being intoxicated, do you have to go get the magistrate out of bed? And what the Colorado court says is, no, this is supposed to be an alternative to that. But the 4th Amendment process that's going to be provided, the equivalent of the Gerstein hearing, because these are necessarily going to be warrantless seizures, is that a neutral decision maker, being an administrator at the facility, I'll represent Denver C.A.R.E.S has one there 24 hours a day, will approve applications so that somebody is going to sit down, write out what the specific instances of conduct, what are the statements made, the non-conclusory bases to believe that the person could be clearly dangerous, and then a neutral decision maker who is on hand at the facility 24 hours a day needs to look at that and either approve or not approve the emergency commitment depending upon whether they believe there's probable cause to believe that there is intoxication and clear danger.
So let me make sure I understand the argument. Are you saying that what Denver C.A.R.E.S needed was something akin to a magistrate to make the decision to keep Mr. Garrett there?
Yes. What we are
And
saying.
are you saying they don't have such a person doing that? Can't the intake people make that decision?
They cannot, because they're behavioral health techs and nurses, and the third-party administrator for purposes under the statute, as I understand it, has a different position. But we are saying they do have that person there. But the way this place operates—
Wait, they do have the person there? Who's that?
I believe the head nurse is one of them. That's who we deposed.
Were these arguments, did you make these arguments in your brief?
Yes, Your Honor.
Well, let me ask you this. They get Mr. Garrett to Denver C.A.R.E.S, and his blood alcohol level is 0.196. So why isn't that alone enough for a reasonable concern about dangerousness, at least to himself? Because that's a pretty high blood alcohol level. What's unreasonable about holding him at least for some period of time at that point?
Your Honor, I think that there are people who at that BAC would be dangerous and folks that may not be, and that's a factual dispute as to whether or not that's clear danger, and probably a factual dispute that involves not only additional information about Mr. Garrett, but perhaps even information from a professional in the field. I think it's beyond the purview of the court, as the trial court did, to step in and make that determination, which realistically is supposed to be made by somebody with experience and knowledge in the field. But beyond—
Well, isn't that what the intake people are? I mean, they do have experience. They deal with this on a daily basis. They're making these decisions all the time. They're trained to make these decisions. And why would courts second guess the reasonableness of that?
So I want to step back very quickly, because I do have an answer to that, and I want to make sure that I've addressed an earlier question that feeds into this, which is the way that things work at this facility. The problem is that this facility, it has the administrator on hand, it has the time and the resources to do the emergency commitment it's supposed to do if somebody doesn't consent. But the way that it works is that when somebody comes in, and we allege in order to avoid having to actually make probable cause determinations on a case-by-case basis, what they do is they presume that everybody who comes in, no matter how they come in, volunteered to be there, is consenting to the detention in the drunk tank. And because of that, the folks at intake, they're not tasked with documenting this sort of specific non-conclusory, instances of conduct that would give rise to belief that somebody is dangerous rather than just intoxicated. And intoxication alone is not sufficient. It's simply not. These are disjunctive. And so
is it reasonable to let someone leave the facility who registers a 0.196, especially when there's at least some risk to the facility that if something bad happens after release, they could be liable?
Your Honor, again, I think that's a factual dispute question, particularly because we've got allegations here that he had a sober ride, a friend who came to the facility to pick him up. And I would refer back to O'Connor, where the courts—
When did he have a sober ride? It wasn't at the point of intake.
No, it certainly wasn't at the point of intake.
So now you're moving on to whether they should have released him sooner.
I think it's all one and the same to the extent that
Oh, well, is it? You just said there was a different standard for Mr. Paddock to take him into Denver C.A.R.E.S as opposed to intake. Why wouldn't the analysis be different as to whether the risk is dissipated and they should release him sometime later that night? Why doesn't seem to me those decisions are the same decisions.
because the way that the trial court assessed this matter, the court essentially said that if the initial determination at the scene by officers and EMTs, if, in the court's judgment, that was reasonable, that probable cause carries through all the way through the 10-hour detention, absent something that undermines the original initial detention. And we believe that's the wrong standard. At the point at which an assessment is made and it's determined he doesn't consent and he is safe to be free in society, and certainly if the court believes that that was not at intake, then I think that again, I would argue that's a factual question. But regardless, even if it's not then, there's certainly several points later in the evening when they were aware that he had a sober ride. They have a counselor looking at him, which is somebody that can do discharge or emergency commitment. And at no point did anybody provide the low barrier process they're supposed to so that he could at least dispute his detention. And that's a violation of the Fourth Amendment unto itself. If I may reserve my final minute.
Let me ask you a question, and then maybe Judge Matheson will indulge you with a little rebuttal. But my question, I'm trying to understand, is your argument ministerial in nature, that they had certain processes that they had to do on intake and while he was there, and because they didn't do them, it doesn't really matter what the facts show? I mean, as far as what Judge Minico saw as the facts.
So, Your Honor, and we're a little bit hamstrung by the underdeveloped record. Our argument is that there is something ministerial in nature here, to the extent that there was no Gerstein equivalent, despite clear allegations that would have been reasonably feasible within the time frame. And so even on that basis alone, this couldn't have been compliant with the Fourth Amendment. In addition to that, our position is that the only way to get to the understanding of the case that Judge Domenico got to, there needs to be any number of inferences made against the plaintiff. And I will, because my time is up, I'm going to give one brief example. The phone call from the neighbor. Not only is it an anonymous tip, we don't know whether the call said that Mr. Garrett was the perpetrator or the victim. You have to presume that it said he was the perpetrator. There's any number of inferences that had to be made against him in order to get to the point that the trial court did, in terms of saying this was reasonable even without the, quite frankly, low barrier Gerstein equivalent process.
Okay, thank you, counsel. We'll see whether we'll come back to you later. Mr. Hood.
Good morning, Your Honors. Elliot Hood on behalf of Denver C.A.R.E.S and the individual appellees. I have a number of points that I want to address that Ms. Levine raised, but I just want to kind of frame the analysis here first. I mean, this case involves two questions. The first question is, was there probable cause to detain Mr. Garrett? And then the second question is whether his detention was reasonable under the circumstances. And if we go to the first question is analyzed under traditional probable cause analysis based on well-settled precedent. In this case, the police came to Mr. Garrett's front yard where a neighbor had reported that he was having an altercation with someone else. They seized him and put him in the back of their squad car, and then they called ESP from Denver C.A.R.E.S to come and take him for detox. When ESP got there, they observed the following. He was verbally aggressive, he was cursing, he had a strong odor of alcohol, slurred speech, a staggered gait, and he admitted to alcohol use. And then when he was taken by ESP to Denver CARES, he blew a .196.
Okay, Mr. Hood, could I just stop there for briefly?
Sure.
And when ESP went to the scene, as I understand it, the complaint does allege, as you described, but is there anything in the complaint to indicate whether the police told ESP about the altercation?
There isn't, but from the perspective of ESP, they're receiving someone from the police who's handcuffed in the back of a squad car, and the police are asking ESP to take this person in for detox. So from the perspective of ESP, it would have been reasonable for them to determine that this person, there was a basis to take this person into detention for detox. They didn't have to have a discussion with the police about what happened. It could have been that they did have a discussion with the police, but that's not alleged in the complaint. But from the perspective of the folks on the scene who were observing Mr. Garrett's behavior, that's what they observed. And Your Honor, I want to address a question that you asked earlier about, when is probable cause assessed? Probable cause is assessed from the perspective of the seizing official. And in this case, that was the police. Mr. Garrett never was unseized. He was seized by the police. He was handed off in a chain of custody between the police, ESP, and then brought to CARES. So the question, and this is what Judge Domenico analyzed, he said, based on the facts, the totality of circumstances that we know based on the allegations in the complaint and the documents that are cited in the complaint, was there probable cause to seize him for intoxication? And if you look at the totality of facts, including what the police would have observed from Mr. Garrett when they got on the scene, the fact that they had a call from a neighbor who was concerned about a fight on his front yard, his condition when ESP arrived there and the notes in their logs, and then his very high level of intoxication when he got to Denver CARES, based on the totality of those facts, there was probable cause to detain him. And I would just remind the court that the probable cause standard is not a high bar. It is a question of probability. It is not a beyond a reasonable doubt standard. It's not even a more likely than not standard. It is a probability standard. And based on those alleged facts.
Mr. Hood,
Yes.
once they get him to the facility, though, and at intake, a fresh assessment is made. They take the blood alcohol, they do observation and so forth. Doesn't that require at that stage its own probable cause determination?
It does not.
Why not?
It does not.
Why not?
There are two problems with that. One is that this court has repeatedly stated that when you have a chain of custody of someone who's been seized, that there's no obligation to reassess probable cause at each chain of that custody. It's reasonable for individuals along the way to reasonably rely on the determination of those that came before.
What if he had come in and the blood alcohol was 0.01 and he was perfectly calm, non-aggressive, and all the rest, and they say, that's too bad, we're going to keep you here. And it seems to me what you're saying is doesn't matter. Once you got probable cause, that's it.
No.
They can do whatever they want.
That's not what I'm saying, and I appreciate the question.
It sounds like what you're saying. Why wouldn't we look at probable cause at the point of intake?
Because when probable cause has been established to seize somebody, the question then becomes, is there observed evidence that would dissipate the probable cause?
Well, okay, what difference does that make? I mean, isn't it just two sides of the same coin? Either you still have probable cause or you don't have probable cause.
The people that are doing intake are not assessing for probable cause. They're walking through a clinical process to establish the care and needs this person has based on their condition in detox. And part of that is getting the person's blood alcohol level. Part of that is taking their vitals. And part of that is creating a care plan for when they're in the facility for detox. The folks that are at the initial intake process are not reassessing probable cause. That's not what they're trained to do. That's not what they're legally required to do.
But counsel, they're making a detention decision. They could cut this guy loose right then and there. So they are making a detention choice. So isn't there still some reasonableness standard that has to come into play at that point?
No, I would agree with you, Your Honor, that they cannot unreasonably detain somebody. There's always a reasonableness standard that applies, but it's not the question that the intake folks are asking is not, is there probable cause? They're gathering facts to help create a care plan for somebody that's there for treatment. They're not asking what the police did, which is there probable cause to seize this person for intoxication? Now, they can't ignore facts that would dissipate or render the initial probable cause determination unfounded. So if he got there and he had no alcohol in his system at all, and he had been brought in there for alleged detox, that would be a fact that they would need to consider under the reasonableness framework. They can't just ignore that fact. There may be, however, some other attendant facts that the person comes in with in terms of their medical condition that they can't ignore either, that might actually support keeping them for treatment. But
I mean,
those
they're making the same the determination's the same no matter what label you put on it, whether he's a danger to himself and others. The police, when they cuff him and stick him in the car, but just, not for criminal purposes, they're making a decision there that he's intoxicated and a danger to himself and others. And then they pass him off to the emergency service officer. And then he arrives at Denver C.A.R.E.S. and they're assessing him to decide if he's a danger to himself or others. So whether you want to call it probable cause or not probable cause, they're all making the same determination.
I disagree. The folks at Denver C.A.R.E.S. at intake, nor the ESP folks who received him from the police are necessarily asking themselves, is this person a danger to themselves or others? Because we ask at the initial seizure point, was there evidence to show this person was intoxicated and a danger to themselves or others? That's an observation made in the field that can't be replicated at Denver C.A.R.E.S. So when he gets to the intake process, the folks who are taking his vitals and taking his BAL cannot properly assess whether he's dangerous as observed by the police in the field. So it's not fair to impose, nor is it reasonable to impose that burden on the intake folks at Denver C.A.R.E.S.
Well, let me ask you a question. Say hypothetically, he shows up. The police thought he was a drunk. The police put him in the car. The police sent him with the emergency service officer, and he comes in. As Judge Matheson posed to you earlier, he's compliant, he's polite, and he blows virtually nothing. Could they keep him just because the police thought he was a danger to himself or others?
The fact that he was brought, all of those facts would need to be taken into consideration to determine whether it was reasonable to keep him. And I can't tell you sitting here today based on the hypothetical whether they could, because those aren't the facts before us. And we would have to take all of that into account to determine whether he should be detained.
So your point is that in my hypothetical where you have someone who's just a regular guy off the street, no indication that there's any problem whatsoever, that we don't know if they could keep him or not. Maybe they could.
Based on the facts that are present at the time, yes, they would have to determine whether he is a candidate for detox. If he's brought in by police, however, and the police send him to Denver C.A.R.E.S. under protective custody, then that's a fact that needs to be considered as well. But that gets to the traditional Fourth Amendment analysis of when a receiving officer is taking somebody who's already been seized, and the receiving officer observes something about the suspect that doesn't match what the report is on that person, then of course they can't ignore those facts. But that's a part of the dissipation analysis, is the original probable cause unfounded. With
does the complaint, counsel, does the complaint allege that the intake people were aware of the altercation back at the home?
It does not.
And what do we do with that? Do we impute that knowledge or not to the intake people?
So it's the same thing as, like a booking sergeant at a jail doesn't necessarily know what the seizing officer knew in the field. The seizing officer sees the basis in the field to seize, and then that person is through a chain of custody brought where he needs to go. And
the booking officer isn't, that doesn't seem like a very good analogy to the intake people who are making whether you want to call it a probable cause assessment or some kind of professional medical behavioral assessment, they're making a new assessment.
Here's what the intake people would have known, Judge Matheson, is that ESP...
Well, it's whatever the complaint alleged, right? Aren't we? We are at the pleading stage, right?
You are right. And what I was about to say is what was alleged and what's in the documents alleged in the complaint. What we know from what's alleged is that the intake people would have known what ESP put in their documentation. And ESP was very clear that they received Mr. Garrett from the police who requested he be taken in for detox. They would have known that. They wouldn't have known about the altercation that led to the initial seizure. Again, that's my point about the folks who are in this chain of custody cannot be required to reassess the initial probable cause determination that is made in the field by the officers who are there on the scene making the determination.
What's your best case that would apply to this situation that holds that?
The Baptiste case, the Stearns case, the Hinkle case, all of which are cited in the briefing, those are clear that officers or authorities in a chain of custody do not have to reevaluate or reassess probable cause.
Well, one of the claims here is, okay, we had ESP pick him up, we had intake keep him there, but then part of the claim is they kept him there too long, right?
Yeah.
So how does your argument about probable cause sort of carrying through this whole episode apply to the point where we get to 11:30 at night, the staffs talk to him, he has a ride home, the counselors talk to him, and the plaintiffs are alleging and arguing that at that point they should have cut him loose. Is that a probable cause determination? What is it?
No.
What if they're right? Maybe you disagree that the allegations support that, but let's say they're a little stronger. That is, maybe they take another blood alcohol and there's nothing there. He's completely sobered up. His friend's there to give him a ride, and they say, no, we're going to keep you for another 6 hours. Why wouldn't they have a good claim at that point that his Fourth Amendment rights were violated?
Well, I'll just say that's not the allegations here.
I didn't ask that, counsel. I'm asking you, would they have a stronger case? And if they did, is it a Fourth Amendment case? I know it's not. That's why it's a hypothetical, but I'm asking you to address the hypothetical.
Sure. So to answer your first question, the analysis is different. It's a reasonable under the circumstances analysis when the detention is happening. It's not whether there's probable cause to seize. He's already been seized. The question then becomes whether the seizure itself, the detention itself, is reasonable under the circumstances. And under your hypothetical, we would have to analyze whether the facts observed as alleged in that circumstance rendered his continued detention unreasonable.
Okay.
And I would say
as opposed to whether they have probable cause, you're saying that's not the question.
Correct.
The question is whether continued detention is reasonable.
Correct. And you look to cases like Garner, where there's an analysis of prolonged detention. The standard is really, it's a reasonableness standard. And you look at whether the detention itself is tailored to the purpose underlying the detention. And here you have someone who was brought in for being highly intoxicated and dangerous. He was held to about the point that he was sober. He was treated for alcohol withdrawal symptoms along the way, and he went home early the next morning. Our position is that that is a reasonable detention under the circumstances.
I think I'm following you a little better at this point. I guess could you sum things up? You're over time, but I probably ought to give you a chance to make one more point if you've got one.
Yeah, I would just point to our brief where we distinguish between protective custody and the emergency commitment process. Counsel for Mr. Garrett is trying to impute the emergency commitment process on the protective custody standards, and that's just different. A person who is an administrator of the facility can make an emergency commitment on the scene, and that has to be based on intoxication and dangerousness, but that is not the same as the police or ESP bringing someone in for protective custody for what they observe in the field. And I would also point out that the Gerstein hearing she's talking about, there's no requirement that a facility like Denver C.A.R.E.S has to have a magistrate-like hearing immediately when someone gets there. The statute actually provides for notification of the right to challenge the seizure, involuntary detention, and the right to a lawyer within 24 hours of the detention. So under the facts alleged here, that process never should have been or needed to be invoked. But that process is built into the statute.
Okay, thank you.
Thank you.
Mr. Hood. If we're going to go with the equal time principle, I'm going to give Ms. Levin maybe 1 minute.
Thank you.
Thank you.
Thank you, Your Honor, and I will try and sum things up and address things. First of all, I would ask the court, in terms of the hypothetical it was discussing, to look at 2023 Westlaw 9235311. That is the summary judgment order in the prior midget case, and frankly, the court was essentially describing Mr. Stecker, one of the plaintiffs who was held and who did obtain a jury verdict based upon the unreasonableness of the holding. Second, I think this comes down to them saying this is all protective custody. Ultimately, what they're asking for is the ability to hold people who there's no claim have done something criminal with no safeguards whatsoever, despite the fact that there is this very low barrier safeguard available. And that's a huge problem because this is where criminal law and behavioral health get very different. This is not supposed to be a punishment. The idea that they don't have to reassess somebody when they show up at what's part of a hospital in order to, that portion of the hospital doesn't need to reassess what a police officer did earlier. This isn't supposed to be a punishment for prior conduct. They're supposed to be held so long as they are dangerous. With that, thank you.
Thank you. Thank you to both of you. It was really an interesting argument and a helpful one to us. So thank you again. The case will be submitted and counsel are excused. All right, I will call the next case. It's Jones versus Brown, number 24-1442. Counsel, Mr. Barrett, you may proceed.
May it please the court. Your Honors, I would respectfully like to request 3 minutes for rebuttal. This is a textbook application of qualified immunity to prison officials. The issue here is whether there is an exception to it. Yvette Brown and Christy Moore respectfully request reversal of the district court's order denying qualified immunity to them. I will address 3 reasons why this court should reverse. First, qualified immunity applies to Yvette Brown because Bernard Jones's underlying federal habeas claim was frivolous and therefore cannot support an actual injury as a matter of law. Second, qualified immunity applies to Christy Moore because transferring Jones at the direction of her supervisor did not violate clearly established law. And the district court's determinations on Moore's knowledge of grievances are blatantly contradicted by the record. Third, this court has jurisdiction because this appeal presents abstract questions of law. Turning to my first point, The black letter law in this jurisdiction states that the plaintiff is the one who bears the burden of persuasion on qualified immunity, which is unlike most affirmative defenses. When a defendant asserts qualified immunity, the plaintiff bears a heavy two-part burden to show, first, that the defendant violated their federal constitutional or statutory right, and second, that the right was clearly established at the time of the violation in the circumstances faced by the defendant. Yvette Brown is entitled to qualified immunity on the first prong, that Jones could not establish a constitutional violation occurred because he cannot demonstrate an actual injury to sustain his denial of access to court's claim. In his proposed petition for writ of certiorari, Jones asserted an ineffective assistance of counsel claim requesting federal habeas relief because of how his attorney handled bite mark evidence. This claim was frivolous. Importantly, Mr. Jones has declined to address the element of his trial counsel's deficient performance throughout this litigation, despite multiple opportunities to do so when Brown explicitly raised the issue. Because of this, he has waived the argument. And
what do you mean by that element? Are we talking about the frivolousness element of access to court's claim?
we're talking about the frivolousness of his ineffective assistance of counsel claim that was in his proposed petition that he claims he was denied from filing.
Okay, and your argument is that they haven't addressed that?
Correct. Throughout this litigation below or in this appeal.
All right.
And
so let's set that aside for the time being. I understand your argument, but if in terms of determining whether there was a frivolous or non-frivolous argument, wouldn't that require analysis of the contents of Mr. Jones's cert petition, the cert petition that didn't get filed?
Correct, Your Honor, and that is in the record, as are the underlying state post-conviction proceedings and the federal habeas proceedings.
Well, I know those are too, but in terms of actually deciding whether the petition itself had a frivolous or non-frivolous argument, it's really a matter of looking at that petition, isn't it?
Correct, Your Honor.
All right, and that's what the Supreme Court would have done if it had been filed. That's all. I mean, that's what the Supreme Court would have looked at.
Correct, Your Honor.
All right. So would that be like, for example, a review of a complaint under 28 U.S.C. 1915 to determine whether a complaint is frivolous? Is it akin to that kind of analysis?
It is close, Your Honor. It is. It would be a frivolousness similar to 28 U.S.C. 1915, but also in the context of a federal habeas claim, which requires heightened standards for proving a claim.
I guess because of AEDPA, is that what?
Yes, because of the Anti-Terrorism and Effective Death Penalty Act of 1996. Especially for, I'm sorry, Your Honor, I did not mean to interrupt you.
Oh, no. In fact, I'm sorry. I think I interrupted you, but well, I'll throw a question in and you can go from there. The cert petition argues that the state court prevented him from presenting evidence on ineffective assistance from Dr. Dial, who was the defense's retained expert, about counsel's failure to provide him with all the bite mark evidence. That may not have been a winning argument, but is it a non-frivolous argument?
It is a frivolous argument, Your Honor, because there's no way for Mr. Jones to maintain that the state court's decision was so unreasonable that it lacked justification and there was no possibility for disagreement. This is a high standard, and his argument under Broomfield that he was prevented from presenting this claim is frivolous for several reasons. First of all,
well, I didn't ask about the Broomfield. Okay. I asked just about Dr. Dial. He said, "Look, I didn't get a chance to bring in this expert in the post-conviction state court proceedings, and that goes to whether my counsel was deficient or not. So that's why I should the 10th Circuit should have given me a COA. Now, again, I'm not saying that that's necessarily a winning argument, but why isn't it non-frivolous? What is it that makes something frivolous?
It is frivolous because it really lacks an arguable basis or any merit whatsoever here. And this is in the context of his argument that he didn't get to present evidence that his conviction based off of the bite mark for his sexual assault was junk science, or that he didn't get to present all of the bite mark evidence. But regarding the junk science argument, the state courts determined that he did not timely present this. So he procedurally defaulted that. And on the federal level, at the level before the Supreme Court, he actually abandoned that argument. He didn't present it when requesting his certificate.
But that isn't why you wanted to call Dr. Dial. It wasn't to challenge the science itself. It was to call Dr. Dial because Dr. Dial, we have a letter from him in the record that says, I didn't get everything that I could have used to evaluate the evidence. So it seems like the junk science is a separate argument from that.
You're right, Your Honor. It is a second argument, but it is related. As far as his Dr. Dial claiming he didn't get all of the evidence, that relates to his counsel's ineffectiveness, alleged ineffectiveness, and he was able to present at the evidentiary hearing several pieces of evidence regarding his allegations that counsel was ineffective, including a report from another expert, Dr. Cardozo, that determined that under his evaluation, Mr. Jones would not have had the bite mark consistent with what the prosecution's expert testified. But importantly, his counsel obtained admissions on cross-examination that the bite mark may or may not have been from Jones. And the Colorado Court of Appeals decision was not only consistent, but correct on clearly established Supreme Court law under Harrington versus Richter and Strickland versus Washington, that even if you take his argument that he did not present an expert on this, trial counsel's strategy was still reasonable, and the court's review on federal habeas claims is doubly deferential because it must show that the Colorado Court of Appeals made an unreasonable determination on whether or not his counsel was deficient, and that the Colorado Court of Appeals holding that under the circumstances his trial counsel's performance was not deficient was so unreasonable that there's no possibility for fair-minded disagreement.
So let me see if I'm following you here. Your position is Dr. Dial, Dr. Cardozo, no doctors of any kind, it doesn't matter because the Colorado courts found after a hearing that his counsel had acted effectively with effective cross-examination, obtaining admissions that this might not have been him. So therefore, because that's not an unreasonable application of federal law, he loses.
Correct, and that he had no chance of success. And also, his counsel sought 2 requests for extension of time to get more testing from Dr. Dial, which the Colorado Court of Appeals also found and was denied from doing so.
So, counsel, I want to circle back to one of my initial questions to you, though, because now you're arguing based on materials in the record about what happened in the Colorado courts at post-conviction hearings and at the Colorado Court of Appeals and so forth, and you have to go back and look at all that. But the cert petition that was to be filed with the Supreme Court, the Supreme Court's only going to look at that cert petition, and a lot of that you're arguing, they wouldn't have the benefit of that. So the question of whether the cert petition was frivolous is really dependent, isn't it, just on what's in the cert petition?
I don't necessarily agree with that, Your Honor, because again, the state court records and the federal habeas records are public, and
Does the Supreme
he's
Court,
required to preserve those
does the
arguments
Supreme
below.
Court, do Supreme Court justices and their clerks go digging into records to determine whether the cert petition has any validity?
I don't have any personal knowledge of that, Your Honor.
Well, that's why I asked you about the 1915. Just look at the complaint. I mean, that determination is just based on looking at the face of the complaint. And is it frivolous or is it not frivolous? And why wouldn't that same analysis apply to the cert petition?
And even if it does, Your Honor, it is still frivolous because, as I just mentioned, Mr. Jones cannot show that the determinations by the Colorado Court of Appeals or the underlying federal of the Colorado Court of Appeals was unreasonable, or that that this court that already rejected those claims was unreasonable. This court.
But let me ask you this: when the habeas district court denied the initial 2254 petition, it granted in forma pauperis status to Mr. Jones for his appeal to the 10th Circuit. Why wasn't that a recognition that his arguments were not frivolous? I mean, if the arguments were frivolous, you wouldn't grant IFP status.
Because
the district court itself that looked at all of this is in effect saying that this is not a frivolous argument.
Well, Your Honor, we have to go from the district court to this court, then to the Supreme Court, and his argument was to the Supreme Court, and his arguments at the Supreme Court were frivolous as on its ineffective assistance of counsel.
Are his arguments to the Supreme Court any different than they were in the district court?
In some ways, Your Honor, they were certainly much more narrow, and he had many more claims at the district court than he did that he submitted to the Supreme Court. And if Your Honor will allow me, I'd like to transition to my second point, which is about Christy Moore, because the clearly established law issue here is dispositive. There is no clearly established law in this jurisdiction that shows that her conduct engaged in retaliation when she acted at the direction of her supervisor. Again, Mr. Jones is the one who has the burden of establishing that Christy Moore violated clearly established law, and the district court made some errors in its analysis. And first, it wholly failed to state the law that it found to be clearly established in the qualified immunity analysis. And none of the cases cited by the district court or by Mr. Jones in his briefing provide that a prison official who processes an inmate's transfer at the direction of their supervisor is liable for retaliation. And because of this lack of clearly established law, the district court incorrectly denied qualified immunity to Christy Moore.
Well, the district court thought there were other facts relevant to that analysis other than just my supervisor told me, right? There were things about knowledge of grievances, meetings that occurred, maybe surreptitious acts that were happening behind the scenes that led to this, not just that her supervisor told her.
Your Honor, with respect to Christy Moore, there were no other surreptitious meetings. There was only one conversation between her and her supervisor, Jim Moore, who's no relation, and Jim Moore is the one who directed her to transfer Jones. And even if Christy Moore knew about
is Moore the one who had the shifting explanation of why he was transferred? Or the arguably shifted? I won't ask you to admit that. It's been argued that she did.
Christy Moore is the case manager 3 who processed the Mr. Jones's transfer. And I see my time is up, but if I may address your question here, Your Honor. Christy Moore is the case manager 3 that transferred Mr. Jones, and her explanation was that her supervisor, Jim Moore, directed her to transfer Jones because he made the law librarians uncomfortable and because they wanted to find him a new change of scenery. And it was also revealed in discovery that Associate Warden Matt Winden is the one who directed Jim Moore to have Mr. Jones transferred. And I want to make the important point, Your Honors, that There have been some cases in this jurisdiction that make the law not clearly established here, even if Christy Moore knew about the grievances. This court stated in Trent versus Oklahoma that it has never held in the First Amendment retaliation context that true subordinate employees can be liable for retaliation. And it also stated in an unpublished opinion in 2017, Muhammad versus Hall, that this court has not yet decided whether a subordinate employee can be liable for First Amendment retaliation when taking orders from their supervisor, whether or not they knew of the alleged retaliatory motive. So at this time, I see my time is up, Your Honor. If I may, I'd like to have a little bit of time for rebuttal, but thank you very much.
Okay, well, we'll see where we are after Ms. Anderson has presented her argument, and we'll turn it over to you, Ms. Anderson.
Thank you, Your Honor. Annie Anderson on behalf of Appellee Bernard Jones, and may it please the court. Appellants seek to expand the 10th Circuit's jurisdiction by asking for an automatic review of every denial of qualified immunity, even where, as here, the denial is based on relitigating well-supported and clearly articulated findings of fact by the district court. And all of this is to distract from the fact that what appellants are truly asking for in this case is for this court to find that a prison official can retaliate against an inmate for exercising constitutional rights, and that a prison law librarian can be the gatekeeper to an inmate's constitutionally guaranteed right to access the courts. But there's no dispute that both the right to access the courts and the right to be free from retaliation are clearly established constitutional rights. And the district court here found that there were sufficient facts on which a jury could find such violations. Now, there's two issues on this appeal. The first is the 10th Circuit does not have jurisdiction to hear the appeal of either Yvette Brown or Christy Moore on the denial of qualified immunity. The 10th Circuit has specifically requested argument on this question of jurisdiction, perhaps recognizing that although appellants attempt to frame their argument as being based on legal errors, the arguments are in fact based on trying to reweigh the well-supported factual findings of the district court. The Supreme Court held in Johnson v. Jones that questions such as this of the sufficiency of the evidence are not reviewable on appeal. And the 10th Circuit has made clear that jurisdiction is proper only where an appellant starts from the proposition of accepting the district court's fact findings as true and then alleging legal errors. But the appellants
what about the question, what about the district court's determination that he was seeking basically a good faith change in the law and that it was not a frivolous claim? Is that a finding of fact or is that a legal conclusion?
And so here, although appellants attempt to frame this as a legal conclusion about what frivolity is, they're not actually challenging what frivolity means. They're challenging the findings of fact of the underlying petition. And although the facts of the underlying petition are dressed up as legal issues on habeas corpus review, it's really questions of fact that are just dressed up as legal arguments. But the issue here is not the standards of habeas corpus petition. And the district court in this case cited law which held Lewis v. Casey, the U.S. Supreme Court case, and Simpkins v. Bruce, and Leak v. Androsky, where there's not a requirement to show likelihood of success on the merits. The question here is frivolity. And frivolity is not equivalent of success on the merits.
But is frivolity a legal determination?
Although frivolity is a mixed question of law and fact, I mean, frivolity does depend on findings here. And here, the district court found that there were questions of fact that led to a conclusion that this was not a frivolous petition. In fact, as to—
Like what?
So there were findings that Mr. Jones had the right to file a petition for writ of certiorari. That is undisputed. That's something that appellants do not dispute.
That doesn't have anything to do with frivolity, though.
So in Lewis v. Casey, the Supreme Court did say that frivolity can be interference with the right to file a complaint. And in Simpkins v. Bruce, this court held that the interference with the right to file a response to a motion for summary judgment, regardless of the merits of the motion for summary judgment response, were denials of access to courts.
Counsel, could we just back up and talk about Mr. Jones's claim against Ms. Brown on access to courts? And I understand your argument on interlocutory appeal. Our jurisdiction is limited, but let's talk about that in the context of limited jurisdiction. So to overcome qualified immunity at summary judgment, didn't Mr. Jones have the burden to show an access to courts constitutional violation? Prong one.
Yes, Your Honor,
Okay.
that is correct.
How did he do that?
Mr. Jones did this by setting forth clearly established law that shows what the standard is.
Well, no, I'm not talking about clearly established law. I'm just saying, how did he show, well, let's put it this way. How did he show that his cert petition presented a non-frivolous argument?
And so I think that there are various facts that go into this question. And some of them are what I started to list. The fact that he had a right to file the petition on May 16th, 2019, that the petition was all but finished except for needing to add page numbers and be printed.
I asked you about the contents of the cert petition, not whether he had a right to file it or whether he prepared it or any of those things. Just the question of whether the cert petition itself presented a non-frivolous argument. Now, did it or didn't it? And did you show that in district court?
Yes, Your Honor, and I appreciate the question, and I understand that there are some differences in the fact question and also the arguable legal merits.
Let's just go to the question then. Go ahead and respond to the question.
And in the district court, Mr. Jones did make an argument that there was arguable legal merit on the basis of the Broomfield argument. We also did make the argument that the petition itself was non-frivolous as a general matter. Ultimately, also as the court—
Well, okay, that isn't going to work. It lets you say why. You can't say it's non-frivolous as a general matter. What was the non-frivolous argument? Now, you mentioned Broomfield. Let me ask you this. Did Mr. Jones in district court on qualified immunity point to anything in the cert petition that had to do with Dr. Dial? Because counsel, quite frankly, Dr. Dial's mentioned multiple times in that cert petition, over 20 times, and he's not mentioned once in your brief, and he wasn't mentioned in district court. And so my question is, if that's your argument, why didn't you make it?
And Your Honor, you are correct that we did not make an argument as to Dr. Dial.
Well, isn't that what is the Broomfield argument then? I mean, the Broomfield argument is that he didn't get to present evidence in the post-conviction hearing. Well, what evidence didn't he get to present?
And it is the evidence of Dr. Dial.
Yeah, but you never argued that to the district court.
But the district court
or in your appellate brief. Now I know you're the appellee, but why didn't you fail to make the burden on qualified immunity in district court?
And Your Honor, I think, not to bypass the question, but I do think that there is something to be said about under the law, what is required for frivolity is not to get into every single argument that could have been made that the Supreme Court—
I'm just asking you to identify one argument that was made, because don't we have to, I mean, there are two elements to this claim. One was whether he was interfered with, and the district court determined that there was a question of fact there. So you don't have to, that's not contested at this point, but what is contested is whether there was injury, and whether there was injury depends on whether the claim was frivolous. And that's where we are. Was the cert petition, how did you show that the cert petition was not frivolous?
And respectfully, Your Honor, I understand that the court believes that what is required for a showing of frivolity is the actual merits of the underlying petition. But part of how we showed that it was not frivolous was by showing that he had the right to file a petition and that what was prevented was his right to
Counsel, the
instate
Supreme Court in Lewis v. Casey said that an access to court claim requires that a non-frivolous claim had been frustrated or was being impeded. It needs to be a non-frivolous claim that was impeded. And you're arguing that, well, if he was impeded, it doesn't matter whether the claim was frivolous or not. How do you square that with the Supreme Court case?
And I think that the Supreme Court case addresses this when it does leave open the door. It didn't address it directly in Lewis v. Casey, but it did say interference with the right to file a complaint can be a non-frivolous actual injury. In Simpkins v. Bruce, this court did not require that the plaintiff show what arguments he would have made in response to a motion for summary judgment, because the fact of the interference with the right is an actual injury. This is not like other cases where we need to dive into all of the merits of the underlying petition because of the fact that there is an actual injury that's non-frivolous by the right.
Let's just be clear then. I take it your position is that once the library was closed on the filing deadline, that's it. There was an access to courts violation.
I think it was when the library was closed and when, as Mr. Jones testified, he tried to access the law library via a phone call and was not given any alternative access, even though there are options available under the prison's own regulations.
And somehow that shows that his claim was non-frivolous.
I think that there is case law to support that. Nonetheless, to go back, we did make the argument that Broomfield v. Kane opens the door for the Supreme Court to allow additional fact-finding. And while I do recognize that we did not cite to Dr. Dial specifically, that is implicit in the argument. And appellants made various arguments about the petition for writ of certiorari.
Mr. Jones made the argument a lot, in a much more robust way than you did in the district court here.
And I will concede that he may have made a more robust finding, but that's because it was a petition for writ of certiorari on a habeas corpus petition that he was.
Well, now you've got a 1983 civil rights claim where you're making the same argument.
Well, it is, and it is somewhat the same argument, but it is also a slightly different argument because the standards for frivolity are not the same as the standards for success on a habeas corpus petition.
What do you think about this? Sometimes when we're looking at a COA, or actually when we're looking at a COA, we decide whether an issue is debatable among jurists of reason. If a court decides that a COA that an issue is not debatable, is that basically the same as finding there's no non-frivolous issue?
I think that I think that is right, Your Honor. I think that debatable and non-frivolous are really ultimately the same thing. Like if there's actually some arguable legal merit, if it's arguable, if it's debatable, it cannot be frivolous. And the district court here did make a clear finding that this was at least debatable legally. And that was in response to—
Well, but counsel, Mr. Barrett points out that there were a number of different claims in the district court. And is it really all that clear whether the granting of IFP status was based on this access to courts claim or one of the other claims? We don't know that, do we?
Well, I mean, the underlying courts didn't hold it was frivolous on any arguments. I mean, it granted in form of habeas. Yes, we don't know exactly what that is. But again, those are questions of fact that appellants argued to the district court that the district court found were not dispositive on the issue of frivolity. Now, Your Honor, I would like to turn to jurisdiction as to Christy Moore. And if you have more questions on Yvette Brown, I'm happy to answer them. But otherwise, I'd like to turn to the retaliation claim. Christy Moore was the Colorado Department of Corrections Internal Classification Committee chairwoman who was responsible for transferring inmates from Fremont Correctional Facility where Mr. Jones was housed. Mr. Jones set forth facts that Ms. Moore participated in Mr. Jones's transfer, that she drafted the transfer paperwork, that she wrote on the transfer paperwork that Mr. Jones needed a change of scenery because he was harassing the law librarians, and that she actually initiated the transfer. Appellants claim that there is an issue of the district court not identifying the clearly established constitutional right that was violated, but the district court here did cite numerous cases which have held that the First Amendment prohibits retaliation for exercising constitutional rights. And appellants claim that there's case law on which there's a question of whether a subordinate truly participated when they're following orders. That's a question of fact that the district court rejected. It found that there were disputed facts as to Christy Moore's knowledge, and specifically on the issue of Mr. Jones's grievances. Now, Your Honors, I see my time is up. I would just like to ask for an opportunity to sum up, unless there are any.
Why don't you go ahead and sum up, and we gave Mr. Barrett a little extra time too. So why don't you go ahead and sum up?
Now, Mr. Jones deserves his day in court, and that's because the district court concluded that a jury should be the one to decide if Mr. Jones was retaliated against and if Mr. Jones was denied access to the courts. Appellants want a law librarian to be the one to decide who deserves access to courts, but such an argument should not stand, and Mr. Jones deserves his day in court. Thus, we request the 10th Circuit uphold the district court's denial of qualified immunity as to both Yvette Brown and Christy Moore, and allow the case to proceed to trial. Thank you.
Thank you, counsel. I think we pretty much given it both sides equal time on this, so I think we're going to bring this to closure. Appreciate both of your arguments this morning. The case will be submitted and counsel are excused. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right, just needed a second to catch our breath before taking this one on. We are now going to hear Alliance of Healthcare Sharing Ministries versus Conway, number 25-1035. And we will start with Mr. Murray.
Good morning, Your Honor, and may it please the court. Michael Murray for the Alliance. With the court's permission, I'd like to reserve 5 minutes of my time for rebuttal, if possible.
We'll see how it goes. Thank you.
This case is about whether Colorado can single out religious groups for burdensome treatment, including subjecting their internal operations, their associates, and their speech to state review. Colorado started with legislative activity targeting quote unquote ministries and ended up with a law regarding quote arrangements. Then Colorado enacted and implemented the law with exceptions for secular groups, including comparable groups such as direct primary care and Masonic fraternal organizations. As a result, the ministries are subject to differential treatment and burdens. The First Amendment forbids this regime, and it should be enjoined. The first claim
Counsel, I thank you for that introduction, which was well stated. You've got lots of claims, and I think we're going to have lots of questions. So if you don't mind, maybe I'll get started, and I'm sure the others will jump in as well. I just wanted to start on your free exercise claim, and wanted to ask you on the element of general applicability of the law. I wanted to ask you about the argument you're making about exemptions. And first of all, the reference in the Supreme Court's Fulton case to a mechanism for individualized exemptions. How have you shown that rulemaking under the statute and I think the Colorado Administrative Procedures Act would apply as well? How would that be a mechanism for individualized exemptions? What's your argument on that?
Your Honor, we don't read Fulton to require individualized exemptions. The language of categorical exemptions goes all the way back to Lukumi itself, which actually talks about how select statutes and laws in general are selective, and there's problems when categories are exempted. And we think that principle carries through Fulton. So I of course, agree with Your Honor that Fulton uses the language of individualized exemptions, which was present in that case involving Philadelphia itself. But I think then Judge Alito's opinion in fraternal order is very instructive here. He actually pointed out that the language from Lukumi carried through Fulton makes it the case that it is worse when there are categorical exemptions. That case involved a beard policy from the police in New Jersey, and they had a categorical exemption for medical reasons, but wouldn't look at any religious reasons. And so, and what Judge Alito said was that actually makes it worse. The same issue is at play, namely that the state is admitting that its policy can have departures. It can be not universally applied. It's just a different mechanism for how that is actually happening. One is individualized, one is categorical. And I think the opinion from this court in Doe's 1 versus 11 is actually instructive in that regard. It's a little bit of a different context. It was a vaccine case involving the pandemic, but in that case, what the state was doing was distinguishing among categories of religions, but it was doing it on an individualized basis because in the law, there's sort of always a tension between rulemaking and administrative adjudication. And so I think both the Fraternal Order of Police case from the Third Circuit and this court's precedent in Doe's 1 through 11 is instructive as to how there is not simply an exemption from Fulton anytime that there's a rulemaking power for a state or local official. And here, of course, we have evidence in the case that the state has in fact used and were implemented exceptions. We have the exception in the statute for direct primary care, of course, which is clearly covered by the text of the statute. But we also have the state's exercise of exemptions for both certain consumer payment plans and certain types of crowdfunding. And so we see a regime where not only are there exemptions and a power to exempt, but that is exercised. And the result is a severely gerrymandered situation where upwards of 85% of the entities and individuals that are subject to the regime are religious. And so we can see how that actually worked in practice.
How was it exercised, for example, relative to crowdsourcing? How did the state, what action did the state take on that front?
The commissioner has rulemaking authority and promulgated a regulation exempting certain types of crowdfunding from the statute.
Okay, so the commissioner has included that in a rule.
Yes, Your Honor. It's in the rule that is exempted from coverage, and so the crowdfunding arrangements clearly meet the statutory definition of facilitating payment for healthcare expenses, as do actually a whole host of organizations. And we can turn to that in a moment if we like. But what the commissioner did was he said, well, that broad language is not going to apply to certain types of crowdfunding arrangement. It does apply to other types of crowdfunding arrangements in full disclosure. So he drew a line, the commissioner did in an actual rulemaking.
Do you need to make some kind of showing though? If the commissioner did that on the grounds that some of these other arrangements, if you will, do not pose the level of consumer risk, maybe that in the commissioner's judgment, the sharing plans do. Why isn't that an answer to your argument? Or is that something that you need to show to get a preliminary injunction?
No. Oh, I'm sorry, Aaron.
Well, that, for example, do entities like that or fraternal benefit societies pose that they truly are similarly situated, that they're comparable, and one of the comparability elements is risk to consumers?
So I think that takes us into a separate part of the general applicability analysis, the comparability analysis.
I agree.
The interest doesn't really affect the exemption issue. Fulton itself, actually, I think, perhaps are in agreement, said that even if no exemption had been exercised, it would still be a problem under Fulton's analysis. But I'm happy to turn to the comparability question if that's where Your Honor.
Yeah, that's where I was going.
Great. So in comparability is assessed based on the state's interest. And that's what Lukumi and Tandon signify. And here the state, though it has jumped around a little bit, I think the state pretty clearly states its interest on 29 of its response brief. The interest, and very succinctly, it's a big record, but I think they do it well there. And they say the interest is in consumer confusion over payment arrangements that are adjacent to traditional insurance, regulated insurance. And that's what they say their interest is. And so then the question is, how does what's going on here and the comparable activities relate to that interest? And I think Tandon and Lukumi are very instructive there. So in Lukumi, one of the interests that the state asserted was public health. And they said, well, public health is more triggered by animal sacrifice than it is by improper garbage disposal by restaurants. The Supreme Court said, no, both of them are actually triggered by public health. Both of those could be a problem for public health. And so that's the sort of way that the Supreme Court analyzed the question at that level of generality, that level of evidence. And the same was true in Tandon as well. In Tandon, the state said, well, what we're concerned about is at-home religious services, worship services. And the Supreme Court said, well, there's all sorts of things that have triggered the same COVID issues. And those range from indoor restaurants to movie theaters to hair salons to retail facilities. All of them trigger the same interest. And it was actually the dissent in Tandon that tried to analyze the precise level of harm, the precise quantification of what is actually a little bit more harmful or even a lot more harmful. That's what the dissent in Tandon tried to do. But the Supreme Court didn't do that analysis, and neither did the majority in Lukumi 30 years ago. They looked at the type of interest and whether the same interest was triggered. The best evidence that the same interest is triggered here is actually that the statutory language, the way the state was trying to capture its interest, covers all of these arrangements, and they have to be, in fact, exempted. So direct primary care had to be exempted by statute. Crowdfunding arrangements had to be exempted by statute. Masonic fraternal organizations are exempted by a different statute, but it's still the same concept. And it's worth pausing on the Masonic fraternal organizations just for a moment. Colorado's law actually distinguishes between Masonic fraternal organizations, which are exempt from regulation, and other fraternal organizations, such as religious fraternal organizations, which are in fact covered by the insurance code. So this is not the first time that Colorado has tried to draw this sort of line in this area. And Masonic fraternal organizations, of course, actually provide insurance, which is clearly what the state is concerned about, unregulated insurance. And so I think that's how the comparability analysis works under Tandon and Lukumi. Now, what the state will say, I'm sure, my talented colleague on the other side will say is, well, look at the structure of these organizations. They're all different structures, and they don't share the same features. And I'll say two things about that, Your Honor. The first is, this is a little bit of an ex post situation. Those structures are not listed in the law. But many of those structures also do exist in direct primary care, which has monthly fees and access to care that's promised. And the same, of course, is true of Masonic fraternal organizations, which actually provide insurance. And so those structures that they've enumerated in their briefing to the district court and this court are actually present in the healthcare sharing ministries and in the things that are exempted. And so, but I do think it is important to take a step back. The question is not the precise level of harm, the precise level of risk, but rather the type of interest that is triggered by the statute. And here, that's the same that interest that is triggered by both. I see that I'm eating into my rebuttal time. I'm happy to keep going or reserve the time for rebuttal with the court's permission.
Other questions? All right, we'll hold off until rebuttal. Mr. Morgan.
Good morning. May it please the court. Reed Morgan for the appellee, Commissioner Conway. This case is not about regulating religion. It is about protecting Colorado's consumers. Healthcare sharing plans are healthcare arrangements that resemble insurance, but lack its guarantees. The law protects consumers by shedding light into sharing plans, religious and secular alike. Prior to the law, Colorado had virtually no insight into sharing plan operations, despite evidence that they conflated their products with health insurance, while still others engaged in financial misconduct that resulted in widespread denials of reimbursement. Because of the law, we know that roughly 60,000 Coloradans are members of sharing plans. The district court correctly denied the preliminary injunction, and this court should affirm. I'd like to address why the Alliance is unlikely to succeed on the merits of its claims, and I'll start with the free exercise claim. The law's text and legislative history show that it was enacted to address documented consumer confusion and harm. Its legislative sponsor called it a data reporting bill, meant to promote transparency. But she also recognized that sharing plans work for people, including for those who hold religious beliefs associated with sharing health expenses. And the record confirms the consumer protection concerns that prompted the law. Many Coloradans enrolled in sharing plans believing they had insurance, only to learn, often after a denied claim, that they did not. And that confusion is understandable. Sharing plans have a similar collection of features to insurance plans. They use insurance terms like comprehensive coverage, deductible, and premiums. And sharing plans are sold by insurance brokers. The record also shows serious misconduct by some sharing plans. Some plans diverted as much as 90% of member contributions to affiliates, leaving little to pay claims. And these concerns were documented by both consumers and healthcare providers, including Children's Hospital, are included in the record before the district court. Religious organizations, including a religious sharing plan, testified in support of the law, recognizing that it would help protect Coloradans who sought to join in sharing plans, including in furtherance of their religious beliefs. The Alliance, in fact, the appellant here, testified in support of a competing version, which had similar reporting requirements, but the reporting was made to the Attorney General's office rather than the Division of Insurance under the version of the law that was ultimately enacted. This legislative history reflects a broad agreement on the law's neutral, consumer protective purpose.
Well,
Counsel, can I just stop
go
you
ahead,
there?
Ms. Judge Ide, go ahead.
Okay. Oh, sorry. So can you address the exemptions?
Yes, I'd be happy to, Your Honor. With regard to the exemptions, the law, the statute that was enacted by the law is titled Healthcare Sharing Plans or Arrangements. By the text of the statute, as well as what's clear from the legislative history as well, it applies to all sharing plans. It does not apply to other healthcare arrangements. Now, the statute also empowered the commission.
Let me stop you for a minute. So is it your position that the crowdfunding, the fraternal organizations, and the direct payment arrangements aren't even covered by the statute?
That's correct, Your Honor. And again,
why is there an exemption for them?
Your Honor, the statute, like I said, it applies specifically by its title to healthcare sharing plans. And then the statute authorizes the commissioner to identify by rule other consumer payment arrangements that are not subject to the statute. And so I think the reason for that provision is to clarify to the extent that the commissioner elects to do so, the commissioner can promulgate rules that clarify other entities that are not sharing plans and are therefore not subject to the reporting requirements.
So to be clear, your position is that you haven't exempted anyone. You have just clarified that these certain groups are not covered by the statute.
That's correct, Your Honor. And again, I would just point to the statutory section title, which makes clear which entities are covered by it, as well as the legislative history, which exclusively referred to sharing plans. There was no discussion that this reporting requirement would apply to all of the other alternative arrangements that the Alliance has invoked here. However, if the court were to disagree with that finding and find that the commissioner does have some exemptive authority, we would also take the position, which is what the district court ruled, that the exemptive authority that is provided to the commissioner here is not the kind of individualized case-by-case ad hoc decision-making that was discussed in Fulton. This is, as Your Honor, raised, I think with opposing counsel, this is a categorical style of rulemaking. And in this court, in Axon Flynn, confirmed that the Fulton concern about individualized exemptions is focused on systems of ad hoc decision-making. That's very different from exemptions that would be promulgated by rule after notice.
Mr. Morgan, could you respond directly to Mr. Murray's argument that they really aren't relying on the language from Fulton about individualized exemptions, that there's case law that also makes the authority to grant by rule categorical exemptions as problematic under a free exercise analysis, because it would make the law not generally applicable. So I'm interested in your giving a direct response to Mr. Murray's argument.
Your Honor, I think Axon Flynn explicitly rejects that contention, and in doing so, it actually cites and I think if you read Lukumi, I disagree with opposing counsel interpretation of Lukumi. The court in Lukumi conducts a general applicability analysis whereby it determines whether the ordinance at issue there was treating comparable secular conduct more favorably than religious conduct. And it does consider whether there are categories of secular conduct that's being treated more favorably. But I think that's separate from the Fulton individualized exemption analysis that raises concerns that some government official could, on a case-by-case basis, potentially, exempt favored secular entities. And so I think the portion of Lukumi that opposing counsel was referencing is really focused more on this question of, does the law treat comparable secular conduct more favorably than religious conduct?
Well, let's pick up on that then, because in the briefing, there's some back and forth over whether whether you want to call them exempted, excluded, or not covered entities are comparable to the sharing plans. And we need to remember we're at the preliminary injunction. Has Alliance made an adequate showing for preliminary injunction? What burden does Alliance have in terms of making that showing on this particular issue to meet its preliminary injunction burden? What's your position on that?
Your Honor, our position is that under Kennedy v. Bremerton, and this is also confirmed, I think, in the Tandon opinion, it is the Alliance's burden to demonstrate that a law is not generally applicable or is not neutral. Excuse me. And in order to demonstrate that, it is the Alliance's burden to identify comparable secular activities that implicate the risks that are being regulated by the government. Because general applicability is concerned, and we know this from Tandon, with the government's asserted interests and the risks that different activities pose to that interest.
Well, are you saying that they needed to present to the district court evidence of risk, or at least an argument about risk, that, for example, the risk of consumer confusion relative to crowdsourcing is similar to the risk of confusion from these sharing plans? Did they have to make that showing before the district court?
I think they did. And I think in some cases that showing is going to be a common sense showing. So I think in Tandon, sorry, I think in tandem, where the government's asserted interest was COVID spread. And, the question was, if you have multiple households gathering together, there is this risk of COVID spread. And I think in tandem, the court could easily see, that in-home religious exercise would gather multiple families together and implicate that risk in the same manner that a hair salon would. But there are other cases, and I think this is one of them, where it's not as obvious that risk presents that different activities present the same risk. And here, we have provided over 500 pages of documented consumer confusion and harm, more than 20 consumer complaints, multiple complaints from providers, regulatory actions taken by other states, litigation, bankruptcy filings documenting that members are not receiving reimbursement. And so we've provided.
Well, let me ask you about this fraternal benefit society. I've been kind of grappling with that. As I understand it, there's actually a part of the insurance code that addresses fraternal benefit societies, and it says in part that they may provide the following contractual benefits: hospital, medical, or nursing benefits. And they're also subject, I take it, to insurance regulation apart from the reporting law here. But as Mr. Murray pointed out, not all of them are. And so aren't there some fraternal benefit societies, he mentioned the Masonic ones, that why don't they come under the reporting law if they're providing what amounts to be a sharing plan?
Your Honor, there's no evidence before the district court or in the record here that fraternal organizations present the same consumer confusion and harms associated with sharing plans that's addressed by the law. For example, if a person is a member of a fraternal organization and obtains some sort of insurance benefit from them, we think it's not, first of all, there's no evidence that fraternal organizations in Colorado even offer health benefit plans.
Well, okay, let me just put it this way. Let's say you did have a fraternal benefit organization, maybe it's a Masonic one, and it actually does do the same thing that the sharing plans do here. That you become a member, and then they facilitate coverage of health care costs. Would the law apply to them at that point? In other words, are they actually excluded? It seems the law is pretty general. And why wouldn't the reporting law apply to them in that situation?
Your Honor, the reporting law, as I understand it, would not apply to them because, again, looking at the statutory title, it is addressed specifically to healthcare sharing plans and arrangements. And I think there's good reason for that, given.
But what if they're actually running a healthcare sharing plan? If they're functionally doing that, I mean, just because they're called a fraternal benefit society, that's just a label. If what they're really doing out there is the same thing, would they be subject to regulation?
I think if there were a fraternal benefit organization that was indeed running a sharing plan under the definition of the statute, that might be covered by the regulation. I'm not aware that there's any evidence in the record that any organization does that.
No, I understand.
It's hard for me to, I guess, answer that specifically. But I think it would depend on kind of the structure of what they are offering and whether it fits the sharing plan, features that are defined in that statute.
It sounds to me like you are making the argument, though, that we have to look at the level that we can distinguish here and that you can distinguish based on the level of risk and not just the type of risk.
Your Honor, respectfully, that's not what I'm trying to characterize. I'm trying to say that sharing plans present a different type of risk. Okay,
so you're saying you don't want that it's unfair to draw the draw the distinction on just a general type of risk, consumer confusion and protection. You would say, well, that's not defined enough.
That is correct, Your Honor. I think that this law was responding to a more specific risk identified arising specifically from sharing plans.
How would you identify the risk?
Your Honor, the risk here is that sharing plans, because they share these key features with insurance, they are regular, and because they are marketed using insurance terms by insurance brokers, they are commonly viewed by Coloradans as providing the same benefits as insurance, when in fact there are important differences in what they provide. And that fundamental misunderstanding leads to consumer harm that flows from that.
Okay, so that is a very detailed type of harm. You want to define the type of harm at a very detailed level.
Well, I was trying to articulate it there specifically, but I think it could be drawn to the general level of consumer confusion and harm associated with insurance plans versus alternative health arrangements. And I see that I'm out of time. So if the panel has no further questions, I'd like to just briefly conclude.
Briefly conclude.
Thank you. Colorado's law doesn't target religion or speech. It was enacted in response to documented instances of consumer confusion and harm arising from sharing plans, secular and religious. The reporting requirements are factual and directly tied to Colorado's compelling interest in protecting its citizens from that confusion and harm. The Constitution permits that, and we respectfully ask that this court affirm the district court's denial of a preliminary injunction. Thank you.
Thank you. Mr. Murray, you have some rebuttal time.
Thank you, Your Honor. I'd like to make several points in rebuttal. The first concerns the exemption issue that was discussed. I think it's pretty clear here that this statute provides exemption authority. The district court rejected the argument that it did not. The definition in the statute of facilitating payment of healthcare expenses is broad. And then, of course, perhaps most importantly, the commissioner did in fact exercise exemption authority. Otherwise, he would not need to do so. There also is in the legislative history.
Well, Mr. Murray, how would you respond to Mr. Morgan's argument that what the commissioner was really doing was just clarifying coverage of the statute? It's not really an exemption if the entity wasn't covered by the statute in the first instance.
I think it's hard to square that argument with the broad statutory language that this statute covers entities or organizations.
One person's exemption is another person's exclusion. Is that kind of what we're dealing with now?
That may be what we're talking about. So it might be a splitting hairs question, Your Honor, or a language question. But I think it's pretty clear that in this particular situation, the statute says this section does not apply to consumer payment arrangements identified by the commissioner by rule. And the commissioner himself seemed to be identifying by rule things that were not covered by the broad language of the statute, which is payment arrangements that facilitate or exchange healthcare expenses. And in the legislative history itself, and this is where Mr. Morgan and I do have a disagreement, there is reference to giving the commissioner this actual authority so that he can exempt, quote unquote, the good guys, as opposed so they wouldn't be covered by the statute. And so I do think even in the legislative history, there's some indication that this is an exemptive authority.
Hey, can I just ask, I think you've split the exemption argument into two parts. Tell me if I'm wrong, but one part is just what exactly is the authority given to the commissioner on the one hand. And then on the other hand, it's the arguments about how there are entities that are comparable and yet they are in effect exempted. This is the comparability. And on that score, of the 8 entities that the parties are briefing, which one is the most closely comparable in your view to the sharing plans?
The most comparable is the direct primary care arrangements, which are exempted by statute. They're clearly covered by the statutory language. Otherwise, the legislature wouldn't have felt the need to make clear that they were not covered. They also involve monthly payments, unlimited access to healthcare, and that's a quote in the record from the Direct Primary Care Coalition's website, and a third party, either it's employers or another third party. So they're directly comparable. I think the second most, and I'll give you two, I think you might have only asked for one, but I'll give you two. The second most is Masonic fraternal organizations, which actually do provide unregulated insurance. So it's not entirely clear to me at all how those could be distinguished from what is covered by the statute. I think those are the two best, but we, of course, have discussed others in the briefing. I see that my time's expired. If, with the court's permission, I would love to take a minute to just wrap up.
Why don't you do that?
Thank you, Your Honor. So in conclusion, affirming the district court's decision here is contrary to Supreme Court precedent in Fulton and Lukumi, Masterpiece Cake Shop, and others, and other circuits' case law. The ruling rests on a novel reading of Fulton that's inconsistent with Judge Alito's opinion and Fulton itself and Lukumi, and it also requires adopting the dissent's position in Tandon v. Newsom, as well as some other case law that we've cited in the brief. This case is all about targeting and singling out the ministries that's not permitted by the First Amendment. That's why we sought a preliminary injunction, an injunction pending appeal, because there's ongoing irreparable harm from this law. We're happy to renew that if the panel, the court is interested. But in sum, we ask this court to reverse the denial of the preliminary injunction. Thank you.
All right. Any further questions from the panel? All right. Well, thank you for the argument. We didn't even get to Establishment Clause, freedom of association, free speech. I mean, this case covers more than a semester course on the First Amendment. But I do appreciate the arguments this morning, at least speaking for myself, hopefully for the panel. I thought you were both quite helpful to us, and we will consider the case submitted and counsel are excused. And as advertised, the court's going to
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
All right, we will continue with our next case, which is Root versus Comstock, number 25-1123. Counsel, Mr. Daniels, you may proceed.
Good morning, Your Honor. I would like to reserve at least 3 minutes of my time for rebuttal if the court allows. Your Honor, I represent Mr. Root, the appellant in this matter, where Mr. Root was an unarmed individual, did not pose a threat, serious physical harm to the officer or the public, and who was in an elevated position at the time, was tased by Officer Comstock, the appellee here. We are appealing the district court because we believe that the district court short-circuited the plaintiff's complaint at the motion to dismiss stage by embedding facts and deviating from the standard of review at a motion dismiss stage. But one of the things I really want to focus on is the issue of the qualified immunity, the issue of clearly established at the time when Officer Comstock deployed his taser towards Mr. Root. Your Honor, this court is aware that when we look at qualified immunity, the law has to be clearly established at the time and a constitutional violation. However, this court not only look for cases within the Supreme Court, this circuit, but also look at weight authority outside of this court. And it is our position that at the time Officer Comstock deployed his taser and Mr. Root, leaving Mr. Root a complete quadriplegic, is that it was not only established, it was well and clearly established that an officer should not deploy a taser on a person that's in an elevated position that's not posing a threat of physical harm to the officer or the public. That's exactly what happened here. This case also deals with an issue, particularly when we're looking at the Graham factors. And I think the most important thing we look at the Graham factors, we conceded the first and third factor that Mr. Root had in fact was suspected of committing a felony, theft, a vehicle theft, and he was fleeing at the time. But the most important factor that we look at, was he a threat to the officer's safety, serious threat to the officer's safety of the public? Because we believe not only this taser, that's categorized as a non-lethal force, if it's used in a manner in which it was used, in this case, it is determined to be lethal force, deadly force. And this circuit have already determined what is considered deadly force. Deadly force is force that carries with it substantial risk of serious injury or death. And tasing a person in an elevated position absolutely carries that potential risk. And Officer Comstock was placed on notice, not just the robust case law that's outside of this circuit, we can get to that point, but not only that, he was placed on notice of his own departmental policies, where it specifically says forbids tasing a person. The officer shall not tase a person in an elevated position or on a surface that likely cause injury or death. Now, in that general order, it talks about exigencies. And I think that exigency makes way when there is a circumstances where even though that person may be on the elevated surface, or that it's cases where an officer should be able to use force, even if that force constitutes as deadly force. It's a case that the district court cited, and I kind of want to point to it, and the district court cited Wilson versus Lafayette case, where an individual who was suspected of committing a felony fled from the officers. And in that case, the officer used his taser, and it was debated as to that he used his search at the time. He didn't really parse out the issue per se with the taser, but more so with the objective reasonableness. And in that case, and the district court kind of relied on that case and decided in this case, it's factually different. The decedent in that case actually reached for a weapon, a potential weapon in his pocket, and looked at officers. In this case, you have Mr. Root, who is running from law enforcement, away from law enforcement. He has a half a gallon of milk in his hand. He's clearly on a elevated surface, and Officer Comstock, with no risk to Officer Comstock, and the district court pointed to that could have been a safety issue because he was running towards the street. However, the issue is there that we're talking about deadly force been used on a potential safety issue, a distant hypothetical here. We're not talking about a situation where you without a doubt, you see a serious risk, danger to the public at large or law enforcement. And I think that's a bad policy where we give officers the right to shoot and tell them out to shoot a person, as well as if you're using a taser in elevated position. It's kind of a distinction, a difference without distinction per se with the tool that's being utilized. And I think that's one of the issues where the district court, where the Court of Appeals in 11th Circuit, when they decided this issue in Bradley versus Benton, a 2021 case that predates this case that happened in 2022, where they went through the analysis, and it wasn't a case that no case was directly on point in 11th Circuit with this issue. There was no binding authority or precedent in the Supreme Court, but they went to Tennessee Gardner, and they equate that tasing a person in an elevated position tantamount to deadly force. And as we know in Tennessee Gardner, that you cannot use deadly force on a person that's fleeing, regardless of the fact they're a felony. It does not pose a danger to the officers or the public. That's clearly established out of the Supreme Court. And this court have actually affirmed that issue recently, as a couple of weeks ago, and I think Fuqua versus Santa Fe, where that a person, and they determined that a person that's fleeing, that's unarmed, that causing a risk to officer safety or others, deadly force cannot be employed. And I think the issue with Judge DeMonico is that the taser component of itself, the lethal, less than lethal, and as to whether a taser can be considered a deadly force, a tool that can consider deadly force. This court have decided that already that tasers, police tools, can be considered deadly force if they use in a certain manner. For example, ass batons. If you strike a person in the head, then that can be considered obviously deadly force. It can result in death. Even handcuffs, even restraints, that's not even geared to be used in any manner. If you use it as a brass knuckles and strike a person multiple times, it can be considered deadly force. So I think the issue was a taser use, particularly versus a firearm. And I think there's a difference without distinction when you're talking about the placing of whether individual or the position, a vulnerable position that a person's is in.
So, counsel, could I just ask you? You early on talked about clearly established law, and now we're talking about whether tasering is deadly force. Is there a 10th Circuit case holding that use of a taser is deadly force?
No, that is not a 10th Circuit case, particularly saying a taser itself is use of a deadly force, but it is a 10th Circuit case that talks about what constitutes as deadly force, anything that causes substantial risk and death. In that case, Your Honor, to this case. This case is Ryder versus City of Topeka, Kansas, and it says deadly force that the actor used with the purpose of causing that he knows to create a substantial risk or death or serious bodily harm constitutes as deadly force. And there's our argument that using a taser in that position Mr. Root was in would constitute as deadly force. That is exactly what the 11th Circuit determined, as well as the 3rd Circuit in Peraza Benitez versus Smith. Although in that case, it was not necessarily dealing with a taser per se. It was dealing with an individual who was struck multiple times that caused paralyzing effect, as though a taser would, and resulted in a fall. But within that case goes through a litany of cases, particularly dealing with tasers, use of tasers as such. And I think one of the biggest things that the weight of authority that I'm talking about is outside of this circuit is that where in that Peraza Benitez Smith case, the 2021 case, it is quoted, "It is widely known among law enforcement that tasers should not be employed against a suspect on an elevated surface because of the risk of serious injury resulting in fall." And this court is aware that a person struck with a taser probes is a neuromuscular shutdown.
Well, counsel, back to clearly established law. to meet your burden to show that the law was clearly established, do you need to rely on out-of-circuit cases to meet that burden?
No, Your Honor. Actually, I think that in this situation, the case, it was so egregious and so well known among law enforcement, the conduct of Officer Comstock, that you don't even necessarily need a case. Obviously, a fact by faith.
Okay, so you'd rely on the sort of the obviousness argument for clearly established law.
Yeah, that's one of the reliance that we have.
Okay. But if you had to rely on a case or cases for clearly established law, what are your best ones?
I think that the best one is Bradley versus Benton is the best case out of the 11th Circuit, particularly the weight of authority out of that circuit, where the courts determined that the height doesn't matter because it's well known among law enforcement that tasing a person that's in an elevated position carries a risk or a serious injury or death. In fact, the expert or taser instructor determined that in the depositions that's within that case. And Your Honor, I know it's not necessarily part of
how elevated. I mean, your complaint alleges that Mr. Root was running down an elevated slope, but can we tell from the complaint whether it was a gentle slope, a steep slope? What is meant by elevated?
You know, I think, and obviously the video was not attached, but however, this slope was significant in this case. Obviously, that's a matter that we would get through.
But how do we know that from the complaint?
Well, we don't necessarily know that from the complaint. I think that is a kind of heightened standard that would be placed on the complaint at that stage. The fact that the complaint within itself say it's elevated, obviously construing facts most like favor to the complaint, that in the courts would have to show that this is an elevated position, albeit it may not.
What is that? What is that? If we view it in a light most favorable to you, I mean, what does that mean? We have to assume it's 4 feet, assume it's a significant drop off where, you know, somebody, if tased, would be likely to break their neck or do something like that. I mean, how do we view basically a vague fact in a light most favorable to you? I mean, how much running room do we have to give you?
I think that the plaintiff should be given a inference in favor as to the elevation, and I think that the main purpose here and the point is that the elevation as relates to tasing a person in an elevated position, even within the Department of Policy, Office of Comstock, there's no definitively or dimension as to what is determined elevated. A person could be standing in a chair that may be 3 feet off the ground, and that would be considered elevated. That could result in serious injury, death if a person is tased. That's why the standard alone within law enforcement that you do not tase a person in elevated position.
This is sort of like almost like a small hill you're talking about, right? It's not a steep drop off or standing on a chair or standing on a wall or standing on a ladder. It's more of a small hill going up to the gas station. Is that right?
No, Your Honor. It's not as very steep per se, but it's not just a small hill. If you going up to the gas station, it's a clear elevation from the gas station to the street on Airport Way here. And this is, I believe if we move forth in discovery, we'll be able to show that particularly, and even with experts to show the dimension of that. And the fact that Mr. Root was tased at the top of that peak of that elevation. He was not tased going further down the slope of the hill or elevation, you would call it. He was tased at the peak of the elevation, essentially flew down that elevated slope, caused his neck to strike against the curve, breaking it and rendering him quadriplegic. So this is not just a small hill we're talking about. It's more than that, Your Honor.
But this brings us back to the original point, I think, is that we can't tell any of this from the complaint.
Well, I think that the inference is drawn in favor of the non-moving party, and we should be given a favorable inference here as such. And I think that that's the issue where a courts intervene as to whether saying, you know, the hill or the elevation itself wouldn't result in serious injury or death, which Judge DeMonico did. So somehow Judge DeMonico took out from the complaint that the hill or the elevation wouldn't cause a serious injury or death. It's within a footnote, I believe, in the judge's order. So that's the issue. The court should not be short-circuiting complaints at this stage when more information may be needed. The question is plausibility. Did we get across that finish line, that threshold under Iqbal and Twombly 2 as to whether plausibility that we stated a claim, which relief can be granted, particularly if we're talking about the elevation element within this case. Your Honor, I would like to also point not just to the qualified immunity issue, that Judge Domenico embedded facts in his claim to fit his analysis. For example, stating that Mr. Root was a danger to the officers due to the fact a prior incident where he fled and inadvertently struck one of the police officers' cars and trying to flee, in which a tracker was placed on him, and embedded within the complaint that Mr. Root was running towards this busy street that would heighten the officers to use some sort of force towards him before he reached the street. You know, that is not the necessarily that is not the standard here as when he's dealing with the motion dismiss stage. And if we point to Barnes versus Felix, recent Supreme Court case, when you're talking about use of force on the Fourth Amendment, you need to look at the totality of the circumstances. The totality of circumstances here. Previously, they encountered Mr. Root. He fled. Tracker was placed, and when they found him and encountered him again, he was at the gas station with a gallon of milk in his hand, half a gallon of milk in his hand, running. He was no longer in the possession of any vehicle or anything.
Okay, counsel, you're over time now. Why don't you go ahead and sum up, and we'll turn to Mr. Stewart.
All right, and the last thing, let's point to the dismissal of the Monell claims. Those claims were brought for ratification that the city of Colorado Springs ratifies officers' behavior. I believe we met the Rule 8 standard, shattered Rule 8 standard to show that that customs and policies created a pattern within the city of Colorado Springs to believe that, but give Mr. Root, Officer Comstock, that he can tase a person against his departmental policies and against well-known practices within law enforcement. And we ask this court to consider that as well.
Thank you, counsel. Mr. Stewart.
Good morning, Your Honors, and may it please the court. Brian Stewart for Officer Comstock and the City of Colorado Springs. Your Honors, this case is about a reasonable split-second decision to stop a fleeing felony suspect. On May 16th, 2022, Officer Comstock used his taser once to stop Mr. Root from running headlong into Airport Road. Officer Comstock deployed his taser only after Mr. Root had evaded and resisted every other less forceful arrest attempt. Because Officer Comstock's decision was inherently reasonable under the circumstances that confronted him, Judge Domenico correctly determined that he was entitled to qualified immunity. Officer Comstock is also entitled to qualified immunity because there is no clearly established law that instructs him not to use his taser in this situation. Mr. Root has not pointed to any case where this court has warned an officer not to tase a fleeing felony suspect simply because that person is running over some sort of undefined gradient. There's also no holding from this court that defines or even discusses the term elevated surface in a Fourth Amendment context. And the amended complaint does not contain sufficient facts to plausibly show that a reasonable officer would have viewed the ground that Mr. Root was on as ground being likely to cause a serious bodily injury when mixed with a taser. As such, Mr. Root has not met his burden under the qualified immunity doctrine and is not satisfied either prong. I'd like to go back to or start with the first prong of analysis. The district court correctly applied the three non-exclusive factors that are ubiquitous to every excessive force case. And all three in this case weigh in Officer Comstock's favor. As Mr. Daniels acknowledged during his presentation, they admit the first and the third factors. The only issue really here is the second factor, and that is, would a reasonable officer view Mr. Root as a threat to the safety of others when Officer Comstock deployed his taser?
Counsel, just as a threshold procedural matter, Did the opening brief actually address the Graham factors?
Did our opening brief or Mr. Root's opening brief, sir?
Mr. Root's opening brief.
I don't believe his opening brief discussed the Graham factors.
Right.
It may have mentioned them, but I don't recall an in-depth analysis of them.
Would it be fair to say, though, that because you addressed them, that you've waived any waiver of that argument?
Well, I suppose so, Your Honor. I mean, I think that's the test that this court applies. Did I answer your question, sir?
Well, you didn't say anything about waiver, and you went ahead and addressed the factors. So I guess my question is whether the Graham factors are in play here.
I think they are. I think they're in play in every excessive force case. But I will defer to the court if the court views otherwise. I will certainly not contest you.
Well, no, I'm asking if you waived the waiver, and what I'm hearing is that maybe you did.
I didn't realize it was something that, to be honest, sir, that could be waived. It seems to me that those factors would apply in an excessive force case, and this is an excessive force case.
Okay, I don't want to belabor the point. Why isn't Mr. Root entitled to a reasonable inference that running down a slope made him more vulnerable to serious injury from a taser?
I think so. What Mr. Root is doing is he's asking this court to view Officer Comstock's decision to use a taser as a decision to use deadly force. And what he's done is he's used this label of an elevated surface as a springboard for that analysis. But if we look at the definition of deadly force, and I'm quoting Geary v. City of Lakewood, deadly force is force that an actor uses with the purpose of causing or that he knows to create a substantial risk of causing death or serious bodily injury. And so we have to look at what Officer Comstock knew at the time and really what he intended. And there are no facts in the amended complaint that would suggest he intended this to happen or that he knew that Mr. Root would suffer this kind of injury.
Well, I think you've gone beyond the question. My question was simply whether by alleging the elevated position or the elevated slope, I guess that's the phrase used in the complaint, why doesn't Mr. Root get an inference that using a taser in such a circumstance poses a more serious and dangerous risk of serious bodily injury?
I think running down a slope might impose some additional risk as opposed to a person running on level ground, but that doesn't make Officer Comstock's decision in this case unreasonable. We have to remember that Officer Comstock, when he tased Mr. Root, he had good reason to suspect Mr. Root of not just stealing that 2017 Ford Fusion, but also of using that car to crash into a police car at the Aspen Lodge. And then when officers caught up with Mr. Root at the Come and Go gas station, he again took flight and ran directly towards Airport Road. This is a public road. It's open to vehicular traffic, and running towards a public road and running into a public road is a very dangerous thing to do.
Well, but wasn't there a little more to the context at that point? The allegation is that, and I think we have to accept the factual allegations is true, that he was unarmed and was fleeing. And so why didn't that make the tasering unreasonable? I understand your argument about the earlier parts of the incident, hitting the car, fleeing, and so forth, and the bolo wrap. But once we get to the point of tasing, don't we just have the suspect who is fleeing unarmed and on a downward slope? And if that's what we have, why isn't tasing unreasonable under those circumstances? Does he really pose any threat?
So he imposes there's an enormous threat there, and it's not just to Officer Comstock, but it's to.
Well, how's he a threat to Officer Comstock if he's unarmed and fleeing?
So I don't think we can presume that he is unarmed in this situation.
Why not? Don't we take the allegations of the complaint as true?
So I apologize, sir. Let me rephrase. I don't think we can presume that it would have been reasonable for Officer Comstock to believe that he was unarmed in this situation. And remember, as Graham tells us, we view these incidents from the perspective of a reasonable police officer on the scene as the situation's happening. I mean, and I know the court mentioned the hitting of the police car at the Aspen Lodge, but I mean that's very relevant even to whether or not Mr. Root is armed or not, because that degree shows a degree of recklessness and a degree of dangerousness. And presumably, a car is a significant weapon. Mr. Root has already used that against police officers. But these are two serious felony crimes, and there would be no reason for Officer Comstock just to presume that Mr. Root was unarmed. And he's running headlong towards a public road, and he's putting Officer Comstock, if Officer Comstock chooses to follow him into that road, and he's putting every innocent driver traversing that road that may be on that road at that time in danger, and any passengers in those cars or any other.
What do we know? We're at the pleading stage. All we should be looking at is the complaint, correct? So what do we know about this road? Does the complaint provide that information that this is a busy road?
The complaint just says he's running towards Airport Road, sir. But
so what does that tell us? How do we get from there to it being a busy road and that he's running towards it, and that's dangerous? Somehow that's dangerous.
Judge, I would submit that running towards any public road is an inherently dangerous thing to do, and it doesn't matter if that road is I-25 or if it's Airport Road or if it's a quiet residential street. In fact, the court in Singleton v. Cunningham, this is a case not in this district, but it did consider there were claims in that case where the suspect, that was his argument, that he said
So if someone is crossing a quiet residential street and the police are pursuing that person, it's reasonable to tase that person.
That person is running headlong towards a public road. Yes, sir. I would say so. We approach all public roads with caution because it only takes one car, and a car could be on even a quiet street at any time. That's why you stop and you look both ways. And in this particular case, Officer Comstock tased Mr. Root before he was able to get all the way into that road.
But doesn't the police department, the Colorado Springs Department policy, call for a warning before tasering?
So the policy says that let me see if I have it right here. My recollection is that it says that a warning should be given if I believe it says if reasonable. But Mr. Root was given several warnings in this particular case. He was given a warning. Officers tried to surround that car and use absolutely no physical force to take the driver into custody at the Aspen Lodge, and force was used against them. They tried again at the come and go.
Let me just ask you, did Officer Comstock violate department policy when he didn't say, stop or I'll tase you?
No, sir. There's not. The policy does not require a taser specific warning. It's just a warning, a chance to comply with orders. And Mr. Root was given several opportunities to comply with police officers.
So they don't have to, so there's no requirement to warn before they tase somebody?
No, sir, and not well, there's no requirement that they give a taser specific warning. The requirement is that they give the person a chance to comply with police officers to, before additional force is used, if reasonable, if possible. And Your Honor, I'll point the court to the case of Thompson v. Salt Lake, and there, this court held that it wasn't necessary for officers to give a warning before releasing a police dog. So I don't think there's a constitutional, Mr. Root doesn't have a constitutional right to a taser specific warning in this case. I mean, the facts of the matter is that, Officer Comstock's decision in this case was inherently reasonable, and Judge Domenico correctly determined that he did not violate Mr. Root's constitutional rights, but Officer Comstock also did not violate clearly established law. And Mr. Root has not pointed to a single case where this court has said that an officer violates the Fourth Amendment by using a taser to stop a fleeing felony suspect who has already evaded less forceful arrest attempts, a felony suspect who has already used force against officers, a felony suspect who is running directly towards a public road, quite possibly the most dangerous obstacle in that immediate area. There's no clearly established law that where this circuit defines the term elevated surface in an excessive force setting. And Mr. Root has not pointed to any case, any published case from any circuit that has used that term in connection with a slope, or as Judge Carson put it, a small hill. And neither has this court, as Mr. Daniels has acknowledged, this court has not viewed a taser as an instrument of deadly force under any set of circumstances. So simply put, Mr. Root has not pointed to alleged facts or law that would have made it clear to Officer Comstock that using his taser in this situation was illegal. And for that reason, all those reasons, Judge Domenico's ruling was appropriate. I did want to point out, Mr. Daniels mentioned Bradley v. Benton, and just wanted to kind of distinguish the facts of that case. My recollection of that case is that the person fleeing, officers pulled over a police car for like a minor traffic infraction, and the passenger got out of that car and immediately took off. He wasn't suspected of committing a felony. He wasn't suspected of committing a misdemeanor. He wasn't really suspected of committing any crime. And then the officer tased him on top of an 8-foot fence. And the court actually said that it was an 8-foot fence. We don't have facts like this here. And I see that I'm out of time. So I appreciate the court. Thank you for your attention. And we'd ask the court to affirm Judge Domenico's ruling.
Right. Thank you, counsel. We're out of time for arguments for this case. So we will consider the case submitted, and counsel are excused. And thank you for your arguments this morning. Right. Our final case this morning is Von Busch versus Board of County Commissioners for Geary County, number 253026. And we will start with counsel for appellant, Ms. Davis.
Good afternoon, Your Honors. May it please the court. Chloe Davis on behalf of appellant Tammy Von Busch. Your Honors, just to make it aware, I do intend to reserve 3 minutes for rebuttal if time permits after the court's questions. Your Honors, this appeal arises out of Ms. Von Busch's employment as the director of the county health department with the defendant appellee, Board of County Commissioners for Geary County, Kansas. Ultimately, Your Honors, this appeal comes down to one question. Was Ms. Von Busch's speech made pursuant to her official duties as the director of the health department? Your Honors, without going too far into the facts, I would like to highlight some important facts that were established in Ms. Von Busch's amended complaint. Ms. Von Busch served as the director of the county's public health department beginning in 2017, and she stayed in that position until her termination in November of 2021. Between 2017 and 2021, she received positive performance feedback from the county. She specifically was described as a good leader and doing an exemplary job. These compliments included making good use of budgets allocated to the department. However, in January of 2021, a new county commissioner, Patricia Giordano, was elected to the Board of Commissioners. Following this commissioner's election to the board, Ms. Von Busch noted concerning behavior by Commissioner Giordano. This behavior included a refusal to allocate necessary funding to the health department and repeatedly exhibiting unprofessional behavior toward county employees and members of the public. This behavior prompted Ms. Von Busch to complain about Commissioner Giordano, including Commissioner Giordano's unprofessional, troubling behavior at monthly public forum meetings and in private social settings. In response, Commissioner Giordano retaliated against Ms. Von Busch by sending harassing emails, making disparaging comments about Ms. Von Busch, and being combative towards Ms. Von Busch. Commissioner Giordano's retaliatory response to Ms. Von Busch prompted Ms. Von Busch to further express concern about Commissioner Giordano's fitness for office to the public in both public meetings and private social settings. Shortly thereafter, Ms. Von Busch received a notice of discipline for, quote, creating conflict, end quote, and, quote, spreading gossip, end quote. In November of 2021, Ms. Von Busch was ultimately terminated from employment for voicing those concerns. I think one thing that is important to mention here, Your Honors, although I'm sure that this court is well aware of the pleading standard at the pleading stage, the Ashcroft-Iqbal standard is just that the complaint provide enough factual material for the court to draw a reasonable inference in favor of the plaintiff.
Ms. Davis, I've got a few questions that go to that, but before I get there, I need to ask you what impact our recent decision in Timmons v. Plotkin has on this case.
I apologize, Your Honor. I'm not familiar with that case. I did not include it in my briefing, so I apologize that I'm not prepared with an answer to your question today.
Well, it issued last week, and it's a Garcetti-Pickering case, and I think both parties and the court are going to have to consider that case in relation to yours. But if you haven't looked at it, I'm not going to push questions about it at this time. So let's get to the complaint. How does the amended complaint describe your client's official duties?
Your Honor, it does not. It does provide some feedback on some of the performance evaluations that she received, which does kind of describe some of the things that she would have been doing in her position. However, the complaint within the four corners of the complaint does not describe any of her official duties in her position.
I mean, the problem, though, is that the first Garcetti-Pickering factor asks the question whether the statements at issue are pursuant to the employee's official duties. And if we don't have anything in your complaint about what those official duties are, how do we apply that factor?
Understood, Your Honor. I think the distinction here is that complaining about Commissioner Giordano and her unfitness for office or her unprofessional behavior would not fall within the duties of a public county health department director. I think that that's a reasonable inference that could be drawn by the court based on the basic understanding of a county public health department. Complaining about a specific county commissioner and their unprofessional behavior or their unfitness for office would not fall within those duties, Your Honor.
Well, does the amended complaint say whether Ms. Von Busch addressed Ms. Giordano's conduct and fitness for office, for example, at the September 27 board meeting?
It does not, Your Honor. The specific paragraph that references the September 2021 meeting outlines her complaints that have to do with funding the health department. What the amended complaint was trying to do was set up why the retaliation occurred specifically. But Commissioner Giordano continued to complain about the behavior of Commissioner Giordano following the September 2021 board meeting in both public forum meetings and in private settings. One thing I would like to also emphasize,
Counsel, the only specific date and location that you have in your complaint about her statements is the September 27 board meeting. So you just said that it doesn't allege that she said anything about Ms. Giordano there. Let's say, though, that she did talk about the budget for the health department. Why wouldn't comments from the director of the health department to the board about the budget of her department, why wouldn't that be within the scope of her official duties? Isn't that her job to defend her budget?
Your Honor, I would like to make the distinction that I think that it is more Ms. Von Busch's job to work with the resources that she's allocated. At the end of the day, her position does not have any final say over the budgetary allotments awarded to the department. And she had been given previous feedback on her successful ability to do just that, which is within the four corners of the complaint, Your Honor.
Well, I'm not sure that that really answered my question. If she stands up in front of the board which controls her budget, allows her and her staff to do her job, and she voices concerns about cuts to the budget or elimination of the department or whatever it is, why isn't that within the scope of her official duties? I mean, isn't it the job of a department head to protect the department, including the financial health of the department?
Your Honor, I think the inference would be drawn that, and I apologize if I'm reiterating what I said earlier, but it's her job to run the department based on the budget allocated to her. So I would say the inference would not be that it's her job to push back on the Board of County Commissioners as to what that amount may be.
So it's not within the scope. Is that what you're saying?
Correct.
Okay.
Correct, Your Honor.
All right. All right. Okay. Well, where did she make these comments about Ms. Giordano? Where the complaint only talks about private social settings and public forums, but it doesn't say to whom she made the statements, where she made the statements, what exactly the statements were they made to the board, were they made in public forums? I mean, the complaint really is pretty thin in terms of telling us what exactly happened here.
To answer your question directly, Your Honor, these statements were made in various locations, and I understand that the complaint doesn't specify whether the complaint or whether the comments were made at her home or at a store in the community. I understand, Your Honor, that it doesn't state that. Ultimately, the comments in reality were made in various places throughout the community that would be considered private social settings. One thing I would like to highlight, Your Honor, is that the language private social settings is not a legal analysis. It's not a legal conclusion. It's not even an element of the Garcetti test, the Garcetti-Pickering test. It is a factor to be considered and whether or not an official is speaking to their official duties or not. However, the language private social setting is not a legal conclusion, Your Honor. And so therefore, our position is that under the pleading standard, it satisfies that standard.
Well, the court thought that those allegations about private social settings were too conclusory. Why wasn't the court correct about that?
Your Honor, so it would be our position that, again, private social setting isn't a legal conclusion. And I think this is where it speaks to the degree of how specific do the pleadings need to be in order to satisfy the Ashcroft-Iqbal standard. And our position is that it just needs to provide enough factual information for the court to draw an inference that plaintiff could prevail based on these facts. And as I mentioned, Your Honor, the phrase private social settings is not a legal conclusion. And so therefore, factually, if accepted as true, the inference could be drawn that if she's making those comments in a private social setting, that she would not be making them pursuant to her duties.
So how are we supposed to know that? Because there are other cases where people have made statements outside of a work setting, purportedly statements between friends, that were ultimately found to be, within the scope of their duties.
Your Honor, I believe that you're referring to the Casey case. If I'm incorrect, I apologize. But I think one distinction that's important here, which I did want to touch on, is that the lower court and the defendants at times seem to conflate Ms. Von Busch's language or her comments, her speech. Part of her speech was within the scope of her department, theoretically. Like if we are going to give that leeway, that the speech about funding the department is within her duties, there's a secondary part of her speech that is about the professionalism and fitness for office of Commissioner Giordano. And the lower court and the county seem to conflate those two things. You'll see it in the last paragraph of the lower court's decision. The court characterizes it as complaints about funding the health department and the behavior of Commissioner Giordano and the influence on the department. However, the speech was two separate topics. And to circle back to your question, Your Honor, the speech about Commissioner Giordano's professionalism or fitness for office made in private social settings or to the public at large, despite who it was made to, whether it was a friend or any other member of the public, would satisfy the pleading standard.
Okay, so I want to on the social setting idea. I guess my only point to you would be is I have a hard time looking at that and understanding what was said in social settings, and who the recipient of the speech was. So it makes it difficult to determine if you can satisfy that. But let me ask you a hypothetical. So let's presume you're at the September meeting and your client is addressing the board and stating concerns about the budget and this and that, and she says, and Commissioner Giordano is attempting to cut our budget. She's acting unprofessionally. We need to push back on that and make sure the budget is preserved so we can keep doing our good work. What do you got there? I mean, isn't that indistinguishable? If that speech is mixed up with the budgetary speech, which we don't know where it was said and not said. I mean, isn't that problematic?
It is problematic, Your Honor, especially in light of the stage of these proceedings at the pleading stage. Again, I think it circles around to what degree of detail is required in the pleadings. To answer your question more directly, I think the court at that point would be required to split hairs and decide, okay, the complaints about funding the department, unprotected because it falls in the scope of the job. The complaints about professionalism does not fall within the scope of the job because it's not the director's job to supervise or oversee the behavior of that commissioner.
So if your client is up basically, and I'm not saying this is how it happened, but on a diatribe to the board and talking about things that are within the scope of her job, and then throws in a couple of personal zingers about the county commissioners, then we have to parse through those and determine which ones are in the scope and which ones are not.
I think such an analysis, ultimately the answer is yes. I think such an analysis would be much more appropriate at like a summary judgment proceeding stage. That's why you guys are tasked with the hard decision of deciding what the standard is at the pleading stage and how specific pleadings need to be. One thing I think, and I see that I'm on time, if I could just answer your question, Judge Carson, a little bit more in depth. One thing I think that's important as well is to note that Ms. Von Busch was disciplined for this exact thing. They call it gossiping. They call it creating conflict. And so clearly the county didn't think that behavior fell within her her job duties because they ultimately disciplined and terminated her for it. Your Honors, if there are no further questions, if I could just briefly conclude.
Please do.
Okay. In summary, Your Honors, the judges are tasked today with figuring out whether Ms. Von Busch's speech fell within the job that she was paid to do. Ultimately, monitoring and complaining about the behavior of Commissioner Giordano did not fall within the job duties of Ms. Von Busch as the county's public health department director. The other thing that the court is tasked with looking at today is the pleading standard, which is well established under Ashcroft v. Iqbal. And here it would be our position that that pleading standard was satisfied. I did not get to touch on the secondary prong of the Garcetti-Pickering test. If I could have a few brief minutes on rebuttal, potentially after we hear from the other side, it would be appreciated. But ultimately, we ask that the lower court's decision be reversed and remanded. Thank you.
Thank you, counsel. Mr. Linden.
Good afternoon, Your Honor. May it please the court. Patrick Linden for the Board of County Commissioners of Geary County, Kansas. The present appeal turns upon a question of the sufficiency of the pleadings. What does a former government official need to plead in order to allege a plausible retaliation claim under 42 U.S.C. Section 1983, specifically as to whether she had engaged in protected speech under the First Amendment? It is not enough to merely allege that one engaged in protected speech. There must be sufficient fact information to demonstrate on the face of the pleadings that the speech was, one, not made as part of the former official's duties, or two, that it concerned issues of public concern. Here, the plaintiff Von Busch's amended complaint lacked the information sufficient to plausibly allege that she engaged in protected speech outside of the scope of her official duties, and that such speech involved issues of public concern. As a result, the district court's dismissal of plaintiff's action should be affirmed.
Counsel?
Yes.
Let me just, again, I don't want to spend time on it if you haven't looked at it, but if you had an opportunity to look at this Timmons versus Plotkin decision.
I did not get a chance to review it before today. During Appellant's argument, I did take a brief review of that. I did see that there was discussion about the scope of what constitutes in accordance with official duties, that one does look at the nature of the duties being performed, not simply whether it concerns information learned in the course of one's official duties. But here, I think the application of Timmons, in my very brief opportunity to review this, needs to be viewed in the context of our plaintiff's context here. She was the director of the Geary County Health Department. She was a top-level employee with essentially broad duties and broad responsibilities for the administration, and I would say good governance of that department, and that touched all aspects of it. Its viability.
Did it touch, counsel? Did it touch this? Was her speech about Ms. Giordano's conduct and fitness for office within the scope of her official duties?
That I don't think we can clearly answer on the face of the amended complaint, because we don't know what the particular concerns being raised were. Were they concerns about her conduct in relation to communications about the health department or issues concerning the health department? Was it involving other aspects of the county's operations? So I don't think we have enough information from the amended complaint to make that call. And that does get a little bit into the second Pickering factor, but first let me walk through the first step of the Pickering analysis, because I think it is truly important here. Again, Ms. Von Busch was the director of the health department. She had broad levels of responsibility. And as this court has said in the first element of the Pickering test, determining what is within the scope of a employee's duties for purposes of determining whether it is speech as part of those duties or outside of those duties, this court has indicated that this is a heavy barrier for most employees. And here, I think the burden is even steeper given the nature of the employment at issue here. When you're the head of a department, that is a very broad range of duties, a very broad range of responsibilities. I would say it has that those duties extend to the full extent of the operations of that department, as opposed to a more subordinate employee that may have a more constrained scope of duties. So here, what we know from the first amended complaint, it starts with an articulation of various concerns that Ms. Von Busch had identified, and then steps to a discussion about raising certain, quote, issues at board meetings. There's no express connection in the amended complaint between that first articulation of concerns and the issues. The only issue that is clearly articulated as being a issue of speech to the board meetings was, I believe, the issue, a rumor about the health department being abolished or dissolved.
Could I just ask you about the board meetings and what we can glean or maybe infer from the complaint about the board meetings? Are these meetings where this is where the board conducts its business? In other words, it actually does consider budget issues and other matters and votes on them, and I mean it's truly they're governing through the board meeting, or are these board meetings more of a public forum? The reason I'm asking this is that I've been wondering whether if Ms. Von Busch is going to the board meetings and she's really there to make a statement to the community at large, does that help her in saying that, look, I'm speaking beyond the scope of my official duties. I'm there to talk to the public, and I'm a concerned citizen too. So what can you tell us about the board meetings? And understanding that we are only looking at the complaint. You may be able to tell us a lot about the board meetings, but we just have to look at the complaint.
I don't think the amended complaint makes that truly clear. And I wasn't involved in this stage of the representation in front of the district court. So I honestly don't have clear knowledge one way or the other of the board meetings in question, what was involved. But even if they were more of an informal nature, not formal meetings to set county policy, if they were communications by the board as a body with its constituents, that's still a function of the government. And I don't think that the plaintiff, Ms. Von Busch, can necessarily step outside of her role as the head of the health department, speaking on health department issues, and say that she's speaking as a private citizen. I don't think those two, I think they are so closely intertwined that you can separate the two, even in a more informal context. If it was just a meeting for public comment. But even a meeting for public comment is still a formal function of the board, if that's indeed what these meetings were, which again, we don't know from the amended complaint, or whether they were meetings to officially decide, deliberate and decide upon county policies, but those are still official functions. So getting back to the first element of the Pickering test, we have the initial statement of concerns, some allegations about raising issues that are largely unspecified before the board. But the issue that is specified is certainly a matter that is directly connected to Ms. Von Busch's duties as the director of the health department. And so at least under the first element of the Pickering test, to what we know about what you said at board meetings, we know that this was not speech protected by the First Amendment. Now, with regard to, there has been some discussion about the conversations in private contexts, and I will agree. I believe it was Judge Ide who made the comment that's very non-specific as to what those conversations were, the context in which they were held, what was said, and even really what the specific discussion about these other topics were. I'm minded of Judge Ide's recent opinion in Peterson versus Williams. It's an unpublished decision. The Westlaw site is 2020 WL 1421959, which I think echoes this case a great deal, in that there too, there were very vague allegations as to what the nature of the speech was, the context in which it was being held, that I think echoes the portions of the complaint here that are talking about these private discussions. We don't know what was said. We don't know to whom it was said, the context in which it was said. And the Peterson case makes places considerable focus upon those circumstances, knowing what was said, what was the context, to know if what was said in those situations was a matter of public interest. And I would also submit whether or not those communications were also in some way tied to Ms. Von Busch's role and duties as the director of the health department.
Well, counsel, the complaint, paragraphs 22 and 23 alleges that the board's disciplinary notice said that Ms. Von Busch had been spreading gossip, quote unquote, spreading gossip, and that her performance evaluation said that she had not shown, quote, good judgment in addressing a rumor with the Board of County Commissioners, end of quote. So why doesn't that help make the private social settings allegations more than just conclusory? Why doesn't that make them sufficient?
I don't think necessarily that from those two paragraphs you can tie that to the private context discussions as opposed to the statements in front of the board. The rumor discussion, or the mention of rumor, I believe, is elsewhere in the amended complaint as being discussed in the context of the board meetings.
Would you agree that gossip and rumor would not be within the scope of her official duties?
I think it would depend on what the gossip was about. Is it related to operations within the health department or Ms. Von Busch's dealings with Commissioner Giordano about the health department? While you might characterize it as gossip or rumors, if it is tied to something that is part of her official duties, I think it is still within that scope. So unless we know what the speech was and the context of it, I don't think we can say that a sufficient claim has been pleaded here, even with regard to the alleged conversations that are in a private context. We just don't have enough factual information in the pleadings before us. The other aspect of this that also I think is problematic in lacking the information about what happened or what was discussed in those private meetings is there's been some discussion about, well, that board member Giordano was engaging in unprofessional behavior or misconduct. I think that starts leading into questions of, well, are we talking about issues that rise to a level of actual misconduct, or are we talking about issues of personal grievance or differences of opinion? The latter have not generally been considered matters of public interest. Now, if there was an allegation here, which we don't have, that Commissioner Giordano had violated the law or acted in a way that was in violation of a county policy, that might be a very different question. But again, we don't have any of those sorts of allegations here. So ultimately, it's a lack of factual detail here that supports the district court's result. The amended complaint we have here does not provide us any factual information that takes Ms. Von Busch's speech and places it either outside of the scope of her official duties, which again were very broad, or clearly identifies, if there were matters outside of that official scope, makes it clear that those were issues of public interest. And so because of this, the amended complaint is insufficient to state a plausible claim for retaliation under Section 1983. And as a result, the district court reached the correct result in deciding to dismiss the claims on the amended petition. If the court does not have any other questions, I am happy to yield the floor back to counsel for appellant.
Could I just ask you whether the district court erred by failing to address Ms. Von Busch's statements about Ms. Giordano's fitness for office?
I don't believe that is error, or even if it is error, that is reversible error here, because again, as I stated a few moments ago, we don't have enough information from the amended complaint as to what the nature of that allegation was. I mean, unfitness for that role, that's a very broad term. And I think without some level of factual details, well, what was the conduct that was the basis of this speech, or what was it about? I don't think we have sufficient information here, again, to cross the threshold to a plausible claim.
Well, thank you, counsel. If there are no further questions for Mr. Linden, and I will take you up on your offer to yield some of your time and let Ms. Davis you've got 1 minute to
Thank you for the court's time.
take us to the end of today's session.
Thank you, Your Honor. I did just want to touch on the second prong of the Pickering-Garcetti test. It was not raised by the appellant on appeal. However, it was touched on by the county on appeal. So I do just want to take a second to emphasize that it's fairly well established in the case law that although speech related to personal disputes or personnel disputes within employment would not be protected. However, this was not about personnel disputes. Ms. Von Busch's speech was related to the unprofessionalism and unfitness for office of Ms. Giordano. And so therefore it was aimed or intended to expose her impropriety or her malfeasance and her unfitness for office. It really had nothing to do with the day-to-day going on of the county health department. Your Honors, I also did want to touch on the Timmons versus Plotkin case briefly. If I understand correctly, what I was able to look at briefly, essentially, as pled in the amended complaint, Ms. Von Busch did have these conversations and expressed her speech in private social settings. So it'd be our position that in line with the recent decision, it would be protected speech based on a very brief reading of the case mentioned, Your Honors.
Understood. Thank you, counsel. Thanks to both of you for your arguments this morning. The case will be submitted. Counsel are excused, and the court will stand in recess until tomorrow morning at 8:30 a.m.
Thank you.
Thank you.